with the consent of the other side, my lord. My lord, this is a NIAC matter basically, and we are unable to trace the petitioner for instructions. So lordship matter may be fixed after the vacation, my lord. On the earlier occasions, we have sought some time, and possibly now we'll have to write a notice or something, my lord. So I've taken consent from Mr. Rupjit De, my lord.
For the, you mentioned for 33, na?
33, my lord. 33, interim may be continued.
For Mr. A.M. Bora, the Learned Senior Counsel, with the consent of the other side, by night, stating that they could not take any instruction from the petitioner, hence need some time. Considering the submission made by them. You want to fix it or after vacation will do?
After the vacation, my lord, let these processes be completed.
After vacation, as well as it will fix by the ministry. Okay, well, listing it after vacation as on it.
Deeply obliged, my
Is
lord.
there any interim? No.
My lord, interim may be completed. Stay matters.
Stay was there.
Stay matters.
Interim. Otherwise, that petition have disposed of, I think.
My lord, because on the earlier occasion, the matter was listed under the, my lord, this thing, stay matters, my lord. Possibly that is why his eye was also there, my lord. Listed. That part.
But if I is there, whether there is any interim.
Well, lordship, otherwise also, because
Otherwise,
NIAC matter also, that will suffice, my lord, what lordship has already ordered. Obliged, my lord.
Ma'am, item number 6, my lord. I'm for the respondent, my lord. I'm speaking a short adjournment, my lord, in this matter till because I have some medical emergency which I have to attend to me. I'm
Today.
my lord. But I have not been able to inform the other side. I couldn't get him, my lord. So
You're for the petitioner? Or
no, I'm for the respondent number 2.
Respond number 2.
Item 6.
Yes, yes.
Legal aid.
Don't know whether is there any urgency of. Oh yes, MS Chaudhary and Chaudhary, you are here, na? They are seeking adjournment in item number 6, seeking that he has some medical emergency.
Item number 6.
Item number 6. Your name is
Yes.
also there, I think. Yes.
Lordship, maybe Lordship as
May I suggest a date, my lord? Either 23 or 22.
Just a second. Item number 6, na? Mr. D. Aforesaid, analytical counsel, paid for the response and with the consent of the other side. Paid for the adjournment. Paid for an adjournment stating some on medical ground. Prayer allot. 22.
22 or 23rd.
23rd. Okay,
23rd,
23rd of this month.
Flood. Take look.
made pleases your Lordship. Another item, Lordship, item number 38, which is listed in the hearing column, Lordship.
Yes.
And the service report was, as per last order, Lordship, it has been served under respondent number 2, but it has been come on hearing list, Lordship. So maybe come up on orders, Lordship.
Orders column. But as per your instruction, service is already.
Also, I have seen the record, Lordship. That's why.
38 MS counsel for the appellant. Okay. And also had Mr. B. Bot, the learned petition being on behalf of citrus. It is submitted by Ms. Chaudhary that by the office note, the service is already complete on the respondent number 2. And the matter has wrongly been listed in hearing column to have been listed in the order. In view of this, let the matter be listed after vacation will do.
After vacation, Lordship.
As
A date may be
by the
fixed, Lordship.
registry in an order.
After vacation, a date, Lordship.
You want the date?
Yes.
16th of July.
16th of July. Lordship, in item number 6, there is, Lordship, interim order
Interim order was
may
there.
be continued.
Interim be continued till next date of listing. Item number 6. Oh,
Obliged, Lordship.
May I please, Lordship? Vacation is item number 37. ma'am.
No,
Can this matter be taken after vacation, ma'am?
you are for the petitioner.
Petitioner. ma'am.
Have you informed the other side?
I'll
Mr.
inform
Mans?
him, madam.
Huh?
I'm trying to call him also. He's not receiving the phone, man. He's known to me, man. I'll inform him.
Considering the submission made by Mr. Bora, the learned counsel for the petition, item 37, adjournment as, however, he is instructed to inform the other side regarding the adjournment. After vacation?
After-
You want any date after vacation or
Yes, madam.
it will, yes,
Any date, man.
any,
Okay.
21st of July,
Obliged.
21 second, this time.
May I please, your Lordship? I'd like to mention with the consent of other side, my lord, item 34, Maybe after vacation month.
Report. Other side is, state is there only.
State month.
Hearing matter, my lord.
Yes, yes.
2 month conviction, my lord. Yeah, they are in bail.
Criminal
Receipt
relief.
of the other side. The Lieutenant Counsel, Mr. Anudin, paid for an adjournment. Prayer allowed, please state matter accordingly after vacation. Want any date here or
My lord, after vacation.
after vacation as an
Simple.
executive? Okay, very
And
good.
my lord, another item, my lord, item 19, on 9. My lord, case there is not received, my lord, so interim is here, my lord. The
Yes,
date
what
may be
is,
given
19?
following the case there.
Item number 19, my lord, is there any not received? Is there any not received? Petitioner is in interim, my lord. Your lordship may kindly fix it next week, any date, my lord.
No, next week.
Then on 23rd of June, my lord.
23rd of, she did not receive, issue reminder. List on 23rd of June, interim be continued till next set.
And interim may be continued.
Yes, yes.
I am blessed.
Please, your lordship, I beg to mention item number 13, my lord.
13.
13, my lord. So this matter will be taken up next week, my lord.
13 scan copy of this year received, my lord.
At the request made by Learning Council petition, that raise the our scan copy of the TCI has already been received. Next week, do we have any date? 24th.
May it please your lordship. Lordship, I beg to mention for listing a bail application for motion for tomorrow, lordship. Below 7 years offense, lordship.
So whatever motion matters before the court number 8 only.
Probably 7 years and above is code number 8.
No, motion mentioned is before court number 8. Make a mention before court number. Mentioning is taken by the senior bench.
Lordship. Oblige your lordship.
May I please, your lordship? I beg to mention item number 22, lordship. Due to some personal difficulty of my senior lordship, matter may be adjourned for
What
2
is the position of
Scan copy of this year.
Scan copy.
this year received?
This year.
The request made by Learning Council for the petition that raised that scan copy of the TCI has already been received. And 23rd of June.
May I please, your lordship. So I beg to mention item number 32, lordship. In this matter, senior counsel Mr. Ken Chaudhary has been recently engaged, lordship, and he has some personal difficulty today, lordship.
He's appealing for the other side. State is there or
No, state is not a party, my lord.
state is not?
Not a-
No one's name has been shown in the cause list.
Name not shown, my lord.
That's why I'm asking, name is not shown in the cause list. Anyway,
After the
you are
vacation,
Mr. J. A. J.
W. Rahman on behalf of Mr. Ken Chaudhary.
You are Mr.
W. Rahman,
W. Rahman or W. Rahman appealing on behalf of Mr. S.N. Sharma.
Ken Chaudhary. He has been
Appealing on
recently
behalf of
engaged.
Mr. K. N. Chaudhary and submitted that Mr. Chaudhary, the learned senior counsel, is recently engaged in the present case. Accordingly, paid for an adjournment. Prayer allowed, please matter. After vacation, as when a date to pick. Do you was there any interim? No. After vacation, it will be listed.
There was an interim, lordship,
That's
that
what
has
I'm
been made
asking, whether
absolute.
there was any interim,
That has been made absolute, lordship.
already absolute.
Hello.
May it please your lordship. I beg to mention item number 26, prayer for withdrawal of the matter.
26, you want to withdraw?
Yes.
Otherwise, what was the position? They were also not on interim, I think.
No, case diary not received.
No, are they on interim? No.
No, interim is not there.
You want to withdraw this?
Withdraw it.
You are Mr.
A. Rekha on behalf of J. Ali.
Mr. K. Dekha, appearing on behalf of Mr. J. Ali, the learned counsel petition. And submitted that with the instructions of the petitioner was to withdraw the same. Mr. Waterford, the learned additional PP, submitted that CD not received and he has no objection in considering the submission made by learned counsel to the petitioner. Matter is accordingly disposed.
Obliged.
May I please, your lordship? I beg to mention item number 39 on behalf of Mr. S. G. Vishwas. Due to some personal difficulties, he won't be able to attend the court. May the matter be adjourned for the day.
39.
39 ki ho sakta.
It's again here, the scan copy was received, na? 39 is fixed with scan is here.
It can be.
It's your eyes. The request made by learned counsel. Addition. Matter is adjourned. However, scan copy of the decision has already been received. Is the matter when you want to. After vacation.
Yes, Your Lordship.
After vacation.
Or maybe the last week of June.
Last week of June 25 and 26, we are not listing
20
any matter. 24th of June.
Next.
Link to 9. Link. He was supposed to be in to VC.
Obviously, in VC.
Link we have already said.
Yes, come.
Okay.
May it pleases me, Lord. I am appearing for the petitioner, my lords. This is a regular bail application.
এটা ওরা ভুলিয়ে পড়াক না, শোনা না।
Am
Just
I
a second, we are increasing the volume.
very well? I'm really sorry for the.
Yes. Yes.
Please, my lords, I am appearing for the petitioner, my lords. This is a regular bail hearing application, my lords. If my lords wants, I'll argue it out, my lords. There is no because it will take some time. That's why I'm asking.
To be honest, the scan copy should be called for of the trial. Then only
We'll do one thing. A hearing is required undoubtedly. It
notice
may be
may
a
be
long
issued to
hearing.
us calling for the scan copy.
So today we most probably scan copy of the TCR along with the case drive will be required
Very well.
for hearing of the matter. So without considering the much time, I think that
It will come on
scan-
bail hearing.
yes, for bail hearing it will come. So in that case, will you be able to come personally or physically before this court?
My lords, if
Will be
it is not much of inconvenience, if I can be on VC, if my lords wants, I'll
No,
come
it's okay.
personally.
You appear through VC, no issue on that.
Very
But
well.
sometimes there is some these technical issues are there. Anyway, we'll try to hear the matter anyway.
Yes.
You are Mr. A. Mishra?
Anil Mishra.
Anil Mishra.
No.
Heard Mr. A. Mishra, the learned counsel for the petitioner. Also heard Mr. Jet Kama, the learned special PP Assam.
Assisted by
P. Dr. P. Dr. The learned counsel for the respondent. Anyone is for the informant is appearing? No.
Today I don't see.
Considering the submission made by learned counsel for both sides, it is seen that the case scan copy of the TCR along with the case drive will be required for the hearing of this case. In view of this, the registry is hereby directed to call for the scan copy of the TCR along with the case diary. Case diary. Yes, and yes, when it can be.
Well,
Yes, for your any convenience,
My lords,
we'll try to adjust.
At the earliest, my lords, I would
So it has
request.
to come.
To getting this scan copy, it may take minimum 2-3 days. So
Well-
maybe we may fix it on the next week then, either 15th, 16th.
Yes.
Okay. I guess Mr. Kamar 16th.
16, I have some problem. Let it be on 17th or 19th, my lord, will be better, man. 1 night. Then everything will be ready, man. If need be, we may also file our objection, man.
Mr. Special Public Prosecutor is suggesting that either maybe 17th or 19th as per
Very good, my lords. At his,
will
at
it be
my
on
lord's
17th?
convenience,
17th, 19th.
19th.
Oh,
19th. Very
yes,
well.
19th of this month, 19th 6. Priesty will coordinate. We are calling for the scan copy TCR and the case diary.
And the case.
We'll hear the matter on 19th of Suez.
May I request Milos for filing some additional documents on behalf of the petitioner?
Now, see, in that case, again, it will not create any problem, but otherwise you have to furnish those copies to the other side also. They may file any objection on that regard.
Yes, yes.
So
I
if
will
it is, suppose we are fixing it on 19 for bail hearing, prior to that,
Prior to
maybe by 15, 16 or 17, as per your convenience, you try to furnish a copy to the other side.
Yes,
So
ma'am.
that if any required, they can.
Yes,
Further
yes.
considering the submission
Advance
made
notice
by,
may be sharper.
further considering the submission made by Learned Counsel to the petitioner, Mr. Mishra, the, the, the petitioner is hereby allowed to file an additional affidavit to produce some documents. However, the petitioner is asked to serve an advance copy to the other side, so that to file any objection if required. Please type. Okay. So you
obliged.
try to furnish it by 15th or 16th of the next week, so that they can, if necessary, they can file an objection.
Much obliged. Much great.
May it please, Your Lordship. My lord, FIR is at page 10, Your Lordship. Lordship, relevant person is page 13, Your Lordship. So FIR in a nutshell is that, Your Lordship, the police.
Who is there, my lord, notice has to.
Your Lordship,
FOXO is there, na?
Yes.
Fox is there, Your Lordship. But
Since when your petitioner is in custody? Since when?
since Your Lordship, 2-4,
Oh,
Your
it's
Lordship.
FOXO. Oh, necessary.
Yeah, 2-4, Your Lordship. Your Lordship, notice will go, even then, Your
Obviously,
Lordship
notice
may be allowed to submit, Your Lordship, that was the case behind, Your Lordship.
Pardon?
Lordship, maybe just submit on the merit of the case, Your Lordship.
To hear. We have to issue notice,
That's-
because
that's-
it is raised
that's-
under 6.
Yes, Your Lordship. Yes, yes.
6 box.
Yes, Your Lordship. But I've been arrested. A short date may kindly give Your Lordship. 2/4/2023, I've been
When
arrested, Your Lordship.
I don't think it will serve your purpose,
And
because notice has to go and we need a report.
I'm an employee of Access Bank, Your Lordship.
No, whatever, you may be an employee, it doesn't matter. Notice has to go.
Other side will try, Your Lordship.
Hmm?
A short date may kindly give Your Lordship. 66 days today as on date, Your Lordship. As on date 60.
You can understand. Heard Mr. A. Devan, the Learned Counsel for the petition. Also heard Mr. A. P. Bot, the Learned Additional PP, everyone status. Issue notice to the respondents. However, no formal notice is required to be served. The state respondent for 1. Copy of the petition may be served during the course of the day. Further, the notice to the respondent number 2 be issued through jurisdictional police station, routed to the office of the registry and public prosecutor. Also call for the case diary list. Am I to open?
24/6.
Along with Your Lordship, PM also, because the victim girl died, Your Lordship, by hanging, Your Lordship. Committed suicide by hanging.
Oh, she died.
Yes, Your Lordship. 17 years, 4 months, the victim age was 17 years, 4 months, and committed suicide by hanging, Your Lordship. So postmortem, I think also.
Call for the along with the CD, along with the PM. PM report.
Lordship.
24/6.
On 25, man.
20,
Let not be fixed on
Oh, yes.
25, 24, let it be on 24/6.
24.
Yes.
May it please, Your Lordship. My
Yes.
lord, petitioner was arrested on 28 February, my lord, 2020. Here also, my lord, FOXO is there, my lord. Section 6 of the FOXO.
It is the charge sheeted case.
Yes, my lord, search.
So as per you, what is the stage of the case? Can you tell us?
My lord, the search has not been framed, my lord. As
Not
per
yet
my
framed.
instruction, my lord.
Not yet framed.
My lord.
You are Mr.
UK does, my lord.
UK does still on counsel for the petition. Also, Mr. P. Bot, same order. Issue notice so and so. No formal notice is required. So and so. Issue notice to the respondent. So, the same order. Also call for the
My lord, the
scan copy of the TCR along with the case diary.
PCR and CDMA.
Yes, scanned copy of the TC along with the case diary and the present status. We are calling for the present status.
Nice.
As per you, when is the next date is fixed? Can you tell us?
I have
Next day?
I have mixed.
When it can be listed? Purva.
Already 101 days, my lord. Yeah.
23rd of this.
Right. Obliged.
Bail prison also.
Yes.
PLS bail application, madam. Basically, the case is this, madam, that the petitioners, madam, are all office bearers of Adivasi Students Union, madam. Now, madam, on 16th of April, there was an eviction drive by the Forest Department, madam, for, madam, evicting the people, madam, who were living in Runikata Forest area, madam. Thereafter, madam, the forest officers, madam, picked some of these villagers, madam, brought to their, madam, office, and there was some allegations of atrocities, madam. Then these present petitioners, madam, they issued a press statement, madam, wherein they asked all the, madam, people of the community to protest before the DC office, madam, on the next day. But on the next day, madam, that is the following day, that is 17th of April, madam, there was some incident of violence, madam, and the entire blame has been shifted upon the petitioners, madam. Though, madam, in the video, madam, the transcript, madam, there was no such, madam, call for any violence, madam. Rather, they, madam, said that you come and protest before the DC and let them take necessary against the erring forest officer. So that is the allegation, madam. We may call for the case diary at this stage, but
Why 326F, 326G? Why these are there?
even 109 is also there. Madam, some allegations of arsoning,
There are specific, yes, there are specific.
arms acts are also there, madam. But Lordship will have to examine whether these office bearers are directly involved in inciting or instigating whoever has committed this, madam. That CD will reveal.
So ultimately, what had happened on that day? The violence took place and
Violence took place, my lord. Some people died also, my lord. Some officials also got assaulted, my lord. Some arms were, my lord, probably misplaced, my lord, from the hands of the forest officers, my lord. So it was a big incident.
so as per how many
And-
your
and
office
all,
bearers are
madam,
how many
5
how many
persons.
petitions? 5.
Right. And around 27, my lord, persons who are named in the FIR have already been arrested, my lord, and their bail petitions are pending before the lower court below.
And from the trial court rejection order, it reflects that there are specific materials against the accused persons.
Okay, then we're calling for the case diary.
Yes.
When it can be picked.
Yes, no. 23rd of 2022.
Can it
Some
be on
problem?
18 or 19? 18, 19?
18, 19, if it can reach, then I don't know. 18, 19,
On 22nd.
Not on the last week, man. Before.
19, we have listed that matter, so better not to list much.
23rd, my lord, it will come.
Yes, sir.
Maybe 22nd. Let it be second. See,
22nd or 23rd.
22nd.
22nd? Yes. Highly open.
Chalo. Can copy or call for your okay? And also,
Yes, we have received that scan.
and also
Can
behind
we-
the bar for last 1 year and 2 months, your Lord, behind the bar, your Lord.
1 year, 2.
So the same gender.
Pardon?
The
Team?
Foxo is there, your Lord.
Wakalat number has been filed, I have seen lordship, by respondent number 2.
2 years.
But they,
And also objection was being raised. It is
They filed their objection also.
They have filed up. I have received the objection.
So
it
can
is
we
important to have them hard lord.
And also I'm behind the bar.
do,
for last-
okay, then we don't it for some time. We'll try to inform the other side. Or do you have any other,
But it is, their name is not reflected, what I have seen. I say reflect as in detail, no?
yes, yes, Mr.
Oh, it is
ML Pandya is there.
It is reflected, Lord.
Yes, and both the and we try to get an, yes, what time? Short day.
Short date, Lord.
Had Mr. R.P. Hacharika, the landed counsel for the petition. Also had Mr. K.K. Das, the landed additional PP, appearing on behalf of state respondent. The name of two advocates have been reflected in the court list, but none appeared for the respondent. However, it is submitted by Mr. Hajarika that they have already filed their return application.
11.
Subsequent, and they considering the prayer made by Hajarika, that the matter be accordingly listed. That's when it can be listed then.
15, Lord. 15 losses.
It's a charge sheeted case, can 17th of this month. 17th of this month.
Possible, I will be out of state.
17,
15 if possible, 15. Monday. On 15.
It will reject that.
Okay.
Deeply obliged, Lord. 15.
May it please, your lordship. But
Yeah, also we have received this scan TCR.
Can copy is
well, it's a case registered under 22C, my lord.
22.
He was arrested, my lord, on my lord 09/01/26. And thereafter, my lord, in the meantime, charge sheet has been laid. And thereafter, charges were framed, all my lord, 19/05/26. 19/05/26, charges have been framed under section 22C, my lord, of the NDPS. And total number of witness cited is 7, my lord. Till that, none of the witness has been examined, my lord. And my lord, contraband which has been recovered from him, my lord, is, my lord, 2,160 tramadol tablets. 2160 tramadol tablets, my lord. So in the instant case, my lord, I am seeking bail, my lord, only on one point. If your lordship satisfies, my lord, that your lordship will turn to page 19 for a once, my lord. 19, my lord. But this is the arrest memo, my lord. Now, lordship kindly have a look, my lord, at my lord, section 36 of the BNSS, my lord.
Yes, what are the
36,
requirements?
yes, my lord. 36 procedure of arrest and duties of the officer making arrest, my lord.
Yes.
My lord, 36B, my lord, to prepare a memorandum of arrest which shall be attested by at least one witness who is a member of the family of the person arrested or a respectable member of the locality where the arrest is made and countersigned by the person arrested. Now, if your lordship sees the arrest memo, my lord, there is no attesting witness, my lord. So that is the only ground, my lord. Now, same BNSS, my lord, section 62, my lord. 62 of the BNSS, my lord. It says, my lord, arrest to be made strictly according to Sanhita. No arrest shall be made except in accordance with the provision of the Sanhita or any other law for the time being in force providing for arrest, my lord. So this is the only ground, my lord. The arrest memo has not been signed by an attesting witness. That is the only ground, my lord. And my lord, the one of the case, my lord, which I relied, my lord, my friend has annexed that order, my lord, that your lordship will find at page 22, my lord, of my petition, my lord.
Yes. Coordinate bench order.
Yeah, page 22, my lord. The operating part will be at page 24, paragraph 6, my lord. May I read, my lord?
Yes.
The learned counsel appearing for the accused applicant submits that while arresting the accused applicant, the arresting authority, though has issued arrest memo, but the same is not in compliance of section 36 of the BNSS 23. He submits as per mandate of section 36 of the BNSS no signature of any witness who is the member of the family of the person arrested or a respectable member of the locality where the arrest was made was taken on the arrest memo. He submits that in view of the aforesaid violation, the arrest of the accused appellant being illegal, the accused applicant should be released on bail only on that ground, my lord. And the court, my lord, while coming to the conclusion, my lord, that your lordship will find at page 26, paragraph 13, my lord. What is discernible from the aforesaid 2 section is that there is a mandate provided by the aforesaid section of 36 that the arrest memo has to be signed by a witness. Either he is a member of the family of the arrested person or a respectable member where the arrest is made. Section 62 provides that no arrest shall be made except in accordance with the provision of the BNSS or on any other law for the time being in force providing the arrest. Therefore, any arrest that has to be made is mandatorily has to comply with the provision and the procedure of arrest while making such arrest. Non-compliance of such provision will be in violation of the mandatory provision, which will in turn make such arrest illegal. Once an arrest become illegal, the arrested person shall have an unfettered right to be set at liberty, that is to be released on bail. So my submission is limited, and I expect the PP to public prosecutor to address only this point, and nothing.
No, Lordship, I want to say here, Lordship, before I go into the 36, Lordship, regarding the materials, Lordship, because he is under commercial quantity, Lordship, and here I have in Lordship, this is a tramadol, and this is a tramadol, Lordship, and the quantity is also in of commercial quantity, so section 37 will attract it. However, in regard to section 36, Lordship, Lordship's judgments are there, Lordship. Several judgments are there where it has been stated that if 48, section 48 is complied with, and it has been in this case, Lordship, complied with, along with the section 36, section 48 is also there, it has been complied. So I have also the one judgment, Lordship, where Lordship has taken care of this point, Lordship. So in my humble submission, I want to state that. And in this record, it is.
Done.
Mr. N.J. Datta, Ilan counsel for the petition. Also heard Mr. A.K. Das, Ilan petitioner PP, everyone for the response. So next question, the section so and so in connection with so and so. Scan copy of the TCR and of the case received. It is submitted by Mr. Datta that the present accused petitioner got arrested in connection with this case on 09/01/2026. And case has accordingly been registered under section 22C of NDPS with the allegation of recovery of 2160 numbers of tramadol tablets, which is of commercial quantity. If further submitted that the case has already been charge sheeted and charge of the case has also been framed on 19/05/2026. However, out of 7 numbers of cited witnesses, no witnesses could be examined till date. Mr. However, without going into the other merits of the case, basically emphasized on non-compliance of section 36 of BNSS, 36 of BNSS, wherein while arresting the, as per which then arresting the, while issuing the arrest memo, there has to be the signature of the either family members, friend, or relative in the arrest memo itself. But in the instant case, that is not complied with, and that apart, he states on section 62 of the BNSS which provides that no arrest shall be made except in accordance with the provision of BNSS or any other law time being in force providing for arrest. But in the instant case, it is seen from the arrest memo that there is no signature of the family members, friend, or relative at the time of issuing the arrest memo. In that context, he also relied on a decision of relied on an order passed by the coordinate bench of this court, wherein also the accused was granted bail, considering for non-compliance of Section 36 of BNSS. Post. Next paragraph.
Well, two orders, well, one more I am giving.
Totally, on two bail, coordinate bench of the order of the order in two bail applications, namely BA number 263 of the 2026, dated 26/02/2026, and BA 299 of the 2026, dated 8/04/2026. Citing the above referred judgment, it is submitted by Mr. Dr. that the case of the present petitioner may also be considered due to, and the petitioner is also entitled for bail due to non-compliance of the mandatory provision of Section 36 BNSS. Next, but Mr. Das will an additional PV submitted in this regard that that is a case of commercial quantity, wherein the use quantity of tramadol tablets were alleged to have been recovered from the person of the accused petitioner, and there are sufficient materials so far collected by the alia, and hence while so far collected by also proved that there was a recovery from conscious version of the accused petition. That apart, case being a commercial quantity, the rigor of Section 37 will affect his case, and he also submitted that there is proper compliance of Section 47 and 48 of the BNSS along with the 36 BNSS. Accordingly, he raised objection and submitted that it is not at all a fit case to extend the privilege of bail to the present petitioner at this stage, wherein some of the vital witnesses are yet to be accepted. Mr. Das submitted that the fit case where and accordingly submitted that the bail is liable to be dismissed. Bail petition is there. Just go through the scanned copy of the TISA at the time of arrest, where from it is arrested. Where from he got arrested? Have you any?
I have flag.
I have flag marked that arrest.
Arrest memo.
Well,
No, arrest memo is okay.
Which can copy to
He is a person from which place?
Bongaigaon, my lord.
He is a person.
Sorry, Gwalpara, my lord.
Gwalpara. And case is registered under which jurisdiction?
Lakshmipur, my lord. That is within Gwalpara district.
Lakshmipur, Gwalpara.
Gwal.
Okay, I'll see. Just operative part, I'll pass you on.
My lord. Can I give one more judgment, my lord, tomorrow, my lord? Because my one point I have not taken, my lord.
No,
Actually,
tomorrow will not. I'll
well,
pass order today.
if
you
today,
want to, make another submission on the basis of another judgment, suppose then we will fix it tomorrow.
Then your lordship may fix it. Lordship is fixing tomorrow, my lord.
Tomorrow, though, it may not be possible because again it will create
Well,
problem.
Then, my lord, only
In
one
that case, maybe Thursday or Friday.
Thursday, my lord, because that one point is there, my lord. Just now going through it, my lord. It was searched from his personal search, my lord, from his body, my lord, not before a magistrate or that point, my lord. So lordship may fix it on Thursday, my
Okay,
lord.
he may raise that point. You also note it down
My lord.
because there are some provision where body search, whether Section 50 compliance is there or not. He may argue on that point. You also see.
But
We were listing it on either Thursday or Friday.
Thursday. Can I go through the LCR, my lord?
Yes.
Here itself, I'll go through the LCR.
Pardon?
I will go through the LCR, if your
Yes,
lordship
here
permits.
only. Yes,
Friday.
On Friday, Lord.
Friday.
Hmm.
Okay, the request made by learning council for the petition, let the matter be listed. আপনি যেখানে মারিছে এটা বেলেগ সেপারেট একটা এডিট কই দিব on that point of view.
My hardened part, my lord.
No, not part. We are not going
Because
to part.
already lordship have dictated that.
No, I have asked her to make it a separate sheet there.
My lord.
Not don't need for part heard.
My lord. Then Thursday, my lord. Thursday কইলো বা কুকুরবার না থাকিব পর
তার যখন উলাই
Thur-
লিখি লিস্ট Yes, Thursday or Friday? Thursday. Oh,
Only 5
Thursday
minutes.
কি
I will take 5. I'm
11,
obliged. My lord.
Okay.
I'm obliged.
List on 11.
একটু সাইড করছেন স্যার
Yes, Lordship. In this case, Lordship, due to miscommunication between advocate and petitioner, NBW
Miscommunication?
between advocate and petitioner, NBW has been issued against the petitioner, Lordship. I have already marked it with the red flag in LTCA.
It is a case of NBW, issuance of NBW.
NBW already
By which order?
already got in bail, Lordship, earlier occasion he already got regular bail. In page
Already regular bail. Why you are here then?
that was he was
কি
non-appeared.
কইছে বুঝি পান
Miscommunication of, because of miscommunication, some.
Advocate and petitioner, Lordship.
So how many days he remain unrepresented?
But already I have marked in with red flags.
Still as then you are mother pining for this. You want to submit that he was on bail earlier. Subsequently, there was
NBW issued against.
Acha. For how many days he was not present? For evidence, accused
Long
by
day.
rules.
I think.
It seems that on 24/12/2024, and the next date was fixed on 21/05/2025 for further evidence. On that day, he remained absent. Then immediately on the next day, why didn't you appear? You could have appeared. Now see, your NBW was issued on in the month of January 2025. Whole year gone. 25 gone. 26, it is now mid of 26. But you appear once on what?
No, not the jail already. He already in jail, Lordship.
So on which date he put to jail?
He was
Arrested, na, subsequently.
he was arrested.
Judicial custody.
In custody in 19/1.
19.
19/1/2026.
Acha, on that day itself, this
18.
custody warrant was
Yes,
issued.
yes.
So from 19/1/2020, he is in custody.
Today is 5 months, 5 months and 7 days old.
5 months, 7
And
days.
7 days.
Yes, but
Yeah, only the order of 9/9/2025 is there, where the issuance of NBW is reflected here, Lordship. But earlier orders are not there. However, Lordship.
no, it's there only. We have received this scan copy.
Okay, okay, Lordship.
Scan copy.
Otherwise, Lordship is on bail. But I have also seen, Lordship, the PW 1 and 2 statements are there, and it is clearly implicating also.
Pardon?
It is clearly implicating, Lordship.
Yes, that's it.
I'm appealing for the amicus response number 2, Your Lordship. Your Lordship, there was some miscommunication between the council and the petitioner, Your Lordship, and the petition didn't appear in the date, Your Lordship, and accordingly, NBW was issued, Your Lordship. And also, Lordship, he was earlier, he was allowed to go on bail also, Your Lordship, earlier occasion, Your Lordship. Also, considering the fact, Your Lordship, is
Pardon?
considering the fact, Your Lordship, is upon Your Lordship, if the bail is granted, Your Lordship.
Bail was earlier granted.
Yes, Your Lordship.
Yes, he was
Yes,
bail. No issue on that.
Yes, Your Lordship.
Now you want to submit anything or not?
No, Your Lordship. Your Lordship, already he was granted bail in the earlier occasion, Your Lordship, and due to some miscommunication, the NBW was issued, Your Lordship.
It seems.
Yes, Your Lordship. Sometimes it happens, Your Lordship, like this. Sometimes it happened like this, Your Lordship, due to miscommunication between the council and the petitioner.
Yes, it happens. You are Mr.
J.M. Sulaiman.
Heard Mr. J.M. Sulaiman, the learned counsel for the petition. Also heard Mr. K.K. Das, the learned additional BP, appearing on behalf of Chair Respondent number 1. And MS as Nazneen, the learned amicus, appearing for the respondent 2. This is an application under section so and so connection. Scan copy of the TCF has already been received. It is submitted by Mr. Sulaiman that the accused petitioner was earlier granted bail, and he was regularly appearing before the learned trial court below and was facing the trial. But on 21/01/2025, there was a miscommunication between the his counsel and the petitioner, and for which he remained unrepresented on that day, and hence, considering his absence, NBW was issued. However, coming to know about the issuance of NBW, he appeared before the learned trial court below on 19/1/2026 with an application for bail, but that has been rejected. And since 19/1/2026, he is in custody. His default was only due to miscommunication with his engaged counsel, and he will regularly appear before the learned session judge and will face the trial if he is allowed to go on bail. Mr. Das, the learned additional BP submitted in this from the record, reveals that petitioner was earlier on bail, but subsequently due to his absence, the NBW was issued. However, he submitted that from the evidence of PW1 and PW2, it reveals that they had implicated the present petition. They have implicated the present petition. Next, para MS Nazdin, the learned amicus appearing for the respondent number, submits that it is a admitted fact that the petitioner was on bail, but subsequently due to absence or miscommunication with his engaged counsel, the NBW was issued against him. Next para, considering this submission made by learned counsel for court, I have also periodic its report. And it reveals that the accused was regularly appearing before the trial court below, learned session judge, additional session judge regularly, but due to his absence on 21/01/2025, the NBW was issued against him. However, he surrendered himself before the court on 19/1/2026 with an application for bail, which was rejected, and since then, he is in custody. Considering all these aspects of the case, and also considering the length of detention undergone by the accused, this court is of opinion that further custodial detention is not required in the present case. And accordingly, he is allowed to go on bail for rupees so and so with the satisfaction of additional session judge FTC's report. Okay, granted.
Obliged.
Obliged.
May I please, Your Lordship?
Yes.
Service copy has not been received. No.
It's related to POXO.
My lord.
Service is still awaited.
As per my lord, office note 66, my lord, 26, service report awaited, my lord.
Kindly please just short this lordship.
Office note, my lord, 662.
So the 14. Your MS?
S Sud.
Her name is S. Sud. Your name is Asani. Oh, it's S. Sud. Then it also for the petition. Also heard Mr. B. Sharma. As per office note, it is 6/6/2026. Service is still awaited for the response number. It was sent before your office through your
My lord,
office.
our office has received the, I have taken the information, my lord. It was sent to the officer in charge of the police station.
So in view of this, the additional public prosecutor is hereby asked to make an inquiry regarding the service of the notice to the response number. Scan copy of TCR has already been received. It is. So you make an inquiry, we'll see to it. And if required, then we may appoint an amicus on the next.
My lord, my lord, my lord. On the
So-
Monday, my lord. Or
Monday?
Thursday, or Friday. As per one.
17th. 17/6.
17 June.
17.
Obvious lordship.
15.
Wait, please, your lordship.
Yes.
So regular bail application. And
R. Bora, oh, you're here. Yes.
610 days in custody, lordship, as of today. Lordship will find the FIR at page 14. Charges are under section 6 POCSO and 65 BNS.
Page 14.
Page 14, lordship. May I read?
Yes.
Stated 20.
Is released on bail. He further submitted that the petitioner, the victim is also remain consistent in her statement recorded under section 180 and 180 of BNS. Mr. Sharma further submitted that the victim was only 10 years of time or relevant time of incident. However, it is the fact that there is a delay in the proceeding, and submitted that PO of the case was presiding officer of the said court was transferred on 12/12/2025 to another court, and thereafter only the new presiding officer has already been already joined in the said court, and hence that is the only cause for delay in recording the evidence of the prosecution. However, considering the nature and gravity of the offense and the prayer for bail may not be considered at this stage. MS, it is the MS Medi, the learned counsel appearing for the response number 2, also submitted that the till examination of the informant as well as the victim, the prayer for bail may not be considered, as there is every probability of tampering with the evidence of the vital witnesses if the accused is released on bail. Next prayer, during this submission made by learned counsel for purposes and have also paid the case rate and the scan copy of it is here. It is an admitted fact that there's a delay in the proceeding, in the trial proceeding, and charge, and though delay proceeding, and though the charge was framed on 10/4/2025, the Gauhati prosecution failed to examine none of the witnesses till date out of 22 numbers of the listed witnesses. The accused is also behind the bar for a considerable period, that is for 610 days, but till that the trial could not be commenced. But in the same time, it is also seen that there was a delay in the proceeding due to transfer of the earlier presiding officer, However, it is a it cannot be denied that there was no such default on the part of the petitioner causing delay in the process. But considering the further on perusal of the record, it is seen that there is a total compliance of section 36 of BNSS, and the signature of the witnesses were also obtained at the time of issuance of arrest memo. The another point raised by the learned counsel for the petitioner is that there was no compliance of section 47 of BNSS, as the grounds of arrest which were communicated to the petitioner cannot be considered as the grounds of arrest, and at best they can be considered as the reason of arrest. Reasons of arrest. Thus, there is no no compliance of section 47 BNSS, which may be also one of the ground for considering his bail. Page 27 is a forwarding report.
Yes, Lordship.
So you are on forwarding report.
Lordship may have to look at the record, Lordship, because I do not have a
But
copy.
47 is, it's not the 47.
No, Lordship. That
Where there is
here,
differentiation
Lordship will
between
have to look at the
the
record.
ground. 47, do you have an XD 47?
No,
also?
Lordship, I don't have a copy. So perhaps Lordship can have a
Then
copy
why
of the record.
on that issuance of diligence? 47 BNSS, but on perusal of the record, it reveals that it was in the 40 the forwarding report has been annexed along with the petition, wherein the ground brief fact of the case has been recorded at the time of forwarding the accused for custody. Then have you gone through the compliance of 47 and all? And it will take time again. Flag 47 and 48 then. Flag it. 47, 48. Those samples were also collected, na? Proper certificate may also obtain. Regulate. Hematology report, everything is there only. Medical report, scan and all. Because he was admitted due to some reason, I don't know. I could not go through the entire record. Thereafter, the notice was issued. You can see, Mr. Or if you need that one, then we have to fix the matter after vacation.
I know.
Takes some time, yeah. Grammatically fine. We insist on 47, then it will be after vacation only.
Very well.
See,
Can have it on some other.
because there are some medical documents where they,
Minor.
or we can pass the order today. And if you think that 47 should be there, then we have to call for again. Because I mean, I just take a
Minor.
remark, but I'm not finding it there.
No,
You
I-
have the copy, no?
No, Lordship, that is my difficulty.
My lord, I will verify, my lord. If not
Yes.
here, my lord, let me call for the registry, will call for the my lord's 47 notice from the court.
How can you say 47? You have to again.
Scan copy, my lord.
Scan.
Oh,
My lord, let me call for appearance status report, my lord, along with the case. Whether in the next day, whether me someone may examine, my lord.
as per you, next date is on 22/6.
Yes.
But after 22/6,
Right.
we have a very thing. Because 23, 24, there are
only
many
2, 3
matters
days
have
left.
already been fixed.
Yes. Lordship may then have it after vacation, perhaps.
But it's a bail matter, no, that's why. You say, otherwise we can pass the order at least for after examination of informant in the victim. That will be the best order because see, if you go by the statement also, it is a very,
Very
Say,
serious,
that
man.
is-
Serious.
she is a girl of
right.
10
hardly
years.
10, 11 years.
Lordship, but perhaps on 47, Lordship may adjudicate. If he's already stayed for 610 days, Lordship, we have a fixed date after vacation. Difficult. By that time, Lordship, one date will go by, perhaps a
Maybe some
judge
problem.
maybe.
So particular about our observation, they do that. So and so, Paki start and so could after hearing the matters at time of deliberation, it is submitted by the Learned Council for the petitioner to be ground for non-compliance of section 47 BNSS. But on pedology, but he submitted that he could not collect the notice under section 47 PNSS. And in the same time, Mr. Sharma, the learned additional PP, also submitted that he is not finding the notice under section 47 PNSS in the scanned copy of the PCR. However, some time will be required to go for the entire case record. In view of this, later another latest scanned copy of the fresh scanned copy of this case record is required, and the learned trial court below is hereby directed to supply with all relevant, especially the notice under section 47, 48, 46, etc., along with the case record and the present status of the record is to be received. Registry will do the needful, list the matter accordingly after. So that I can return 14, 15 for it. We are reappearing day is on 14th, so we are listing it on 15th.
Very well.
57th. Let us see if you can also collect any certificate copy.
Well takes.
In the meantime, let past the 22nd of June it is fixed. There may be some development also. Okay.
Obliged, sir.
11th, you will be able to. 15th is a Monday.
16 months.
My lords, 11, if 11 is possible, it is a really urgent matter.
You will be able to. 15th. Oh, sorry, on the 11th of June.
16 minus.
My lords, 11th will be fine.
Why? 11th will be fine. Why?
My lord, because
What
the
is it?
urgent-
Tell us, what is the urgency?
My lord, there has been
2-3
a stay
days you are not
operating.
going to compromise. What is the urgency? Just tell us.
My lord, the stay has been operating on
Oh,
the
what
entire
is this? The stay is
investigation.
operating. Yes, I can understand that apart. Is there any other urgency?
lords,
What is the urgency of this case? Just tell us. I want to hear. What is the urgency? Stay is operating. I can understand. So what is the stage of the case? What is there? Just tell us.
My lords, my seniors have been.
No, you just tell us. You know, you should know. You have come before this court seeking, objecting to the date. Yes, I can understand. There may be some urgency. No issue on that. But what is the urgency? Why you are insisting on 11? He is saying that maybe 16. Can it be? You're saying that no, not at all. It will have to be on 11. So what is the urgency? Just tell us. Stay is operating. It's okay. That apart. What is the urgency of that? Do you have the brief? Go for the hearing today. No, otherwise.
I apologize, my
16/7. Okay. 16/6.
Much
16? 16th of this June. June, though, isn't it? 16 June, though. Yes, 16.
It's a hearing date.
Yes, it's a hearing date.
apologies.
Yes. Just I want to tell you one thing. There are some hearing matters. I don't know, 2-4. Most of them are already been adjourned, I think. There are some hearing matters, and that apart, some admission matters are there. I'm not going to take any admission matters and the hearing matters. I'm finding some difficulty. I am not in a position.
We noticed something there in your lordship.
Yes, I'm just feeling I have come
So that your
on
lordship
a wheelchair.
take rest, my lord. Because we
Wheelchair.
noticed.
Yes, so I'm feeling very pain.
Yes,
So
yes, ma'am.
I may not take this admission as well as the hearing matters.
Yes,
So if I have any date, we can accommodate the dates.
Your lordship will take it.
What remain? Only 35. 35. 2 matters are left. No, only 35 left. Sorry, 35 and 36. So is there any counsel for 35 and 36? If it is not okay, we'll see to it. Okay, no issue. Yes,
My lord, my lord.
Item number 6, Lordship, 16, charge sheet submitted, Lordship.
My lord, today is 59 days, madam. 60 days treasury period, madam. Your lordship may pass the order, madam, so that I may be. Once I go to there, madam, again normally, madam. 59 days of
it is 60 days statutory.
60 days treasury period, madam.
Okay, then let it
Yes,
go.
ma'am.
Otherwise, what was the section? Under which section charge?
Yes, your lordship, immoral trafficking by 3, 4, 5, 7. All are below 7 years, madam.
Yes.
And so for 61 is criminal conspiracy, 143, it is not less than 7 years, may extend to 10 years, may extend to 10.
But since it's charge sheet submitted,
And-
Lordship, it has to be on merit, Lordship.
Marksheet submitted, I am in custody.
He's
For
basically
ends of
switching
justice,
off
my
the
daughter.
line.
Yeah, other is all the actually already granted bail, man. All others, man. Total 5 persons arrested. And only thing is, my daughter, owner also arrested, my lord. And 5 persons total, the 4 already got paid, my daughter. This order is there, my daughter, already got. Then from legal point is also there, but I'm not arguing on merit at this time, man. So your lordship also not well, my lord.
It is 345 of immoral.
Yes. 3, 4, 5, 7. In all are below my lord 7 years. Others got on 46 days, my lord, all others got bail, my lord. Since we filed earlier, my lord, so yeah. Should I give books, my lord? Or it is,
No. Is any ladies were also involved here?
No,
Lady
they were all,
accused?
as per FIR, they are all found in the hotel. With my lord guards, 2 guards, 25 years and 21 years, my lord. Owner was asked owner did not give any reply about the entry also was not made, my lord. So owner is also arrested.
Your petitioner got arrested with the girls.
Not my lord, according to them, anyway, my lord. Now,
whatever.
assuming, yes, according to them, my lord, 5 persons are found in the car. 5 persons, my your lord, this 5 are page 13. 5 persons. All 5 persons, my lord, out of 5, already 4 already got bail. Except myself. And order also I am having, my lord. But then, that is court's below order, your lordship is not bound, my lord, that here. My
Yes,
question,
but
charge sheet
that's-
file, my lord, 59 days today, my lord. Tomorrow, I will get certificate with tomorrow, my lord, by the time 60 days will be over. For the end of justice, I pay your lordship, my lord, your lordship. my lord.
Yes, any.
I only want to state here, Lordship, his name is in the FIR also, Lordship.
Yeah.
And he was also apprehended at the point, same place, Lordship.
Yeah, that's it. Everything admitted,
Otherwise, I'll leave it to Lordship.
everything admitted, my lord.
And moreover, 3, 4, 5, 7 of immoral topic is also there, Lord.
That is the main section, 3457, immoral.
Lordship, immoral.
Arrested on 11/4/26. Today is 59 days.
Hard to say, Chari Chaudhary, the London Senior Counsel, assisted by Mr. Ayu Chaudhary. And also by Mr. K. Ketansi, the additional people appearing on. Case was picked today for case diary, but it is submitted by Mr. That's that case has already been translated. Yes, CS number.
KCS number is 80/26 dated 30/05/2026.
And accordingly, he submitted that the petition for regular bail may be filed before the learned trial court below, which may be considered for this one. Next, right, in that context, Mr. Chaudhary, the learned senior counsel, submitted that the accused petitioners were, petitioner was arrested on 11/4/2026. Until today, he is in 59 days in custody, and hence considering his period of detention, he may be released on. He further submitted that the case is basically, the case is registered under section 61(2), 143 PNS, read with section 3, 4, 5, and 7 of 5/7 Immoral Trafficking Act, wherein the statutory period of 69 days, as all the sections are, no, that 69 days. The IO got sufficient opportunity also to interrogate him, keep him in custody, and hence further custodial detention may not be required for the purpose of trial. Mr. Expert, Mr. Das, the Daniel petition is of fiction and submitted that there is nothing for he cannot make any submission on the basis of merit. However, the present petitioner is an after named accused, and he got apprehended at on the spot, along with the other accused. Expert, Mr. Chaudhary, the counsel for this petition further submitted that 5 numbers of accused persons were arrested at a time, and out of which 4 numbers of accused persons have already been by the trial court. Hence, considering the case of the present petition against him, he may also be released on the ground of death. Considering this made by Raleigh Constable Police without going further detail into the merit of the case, only considering the length of detention undergone by the petitioner, this court is of opinion that through the case has already been charged, the petitioner is entitled to go on with. It is before which
CGM Golpa.
CGM Gulf. Satisfaction of CGM Gulf. Yes.
This case came last time before Lordship, my lord. Education is that man some sal goods locks, my lord. August.
Sal logs.
Yes, sir. Kindly say page 14, my lord. Page 14. Page 14. These all are recovered, my lord. I am just checking, my lord, your loss will find. After arrival, I am not giving first paragraph, my lord. On getting information, after arrival, the so-and-so Gauvras operation was conducted and upon search found the following item. Your loss got it, my lord. In an abandoned condition inside a jungle near newly formed community hall of the said village. Your loss will find these items, main number 5, total 27 numbers of extra locks suspected to be sal trees, my lord. Then all these recovered items were duly seized in presence of the witnesses, namely so-and-so. So, my lord, it was seized from the abandoned place. Everything seized, my lord. And so far, my lord, my part, page 15, kindly see, my lord, what they are saying. Page 15. Page 15, my lord, investigation summary. Your lordship got it, my lord. During the investigation, it has been found that Abul Sheikh, so-and-so is allegedly the main involved in the smuggling of sal dogs for the last 10 years. And it is found that he has no known source of income, yet he is living in a high standard lifestyle. Now, in response to that, we find an additional affidavit saying that, my lord, I am taxpayer, I am giving GST, all the annexes I have given. Page, my lord, your lordship will find everything I have given from page 24 onward, my lord. Now, my lord, basic question is, my lord, here in this case, my only question, my lord, is your lordship kindly see that this person, he is a development village council chairman, village council development point under the BTC. And your lordship kindly see page 10. I am just giving him
page 24.
Page 10 of the
10.
petition.
10.
Page 10. I'm just giving my lord. They are basically saying that without known of source of income, my living state, my lord, very high. Page 110, sorry, 10, my lord. Your lordship will find in pursuance of the approval accorded by the BTC authority of Indian so-and-so, the so-and-so is hereby constituted by the following person. My name is number 1. By the chairman, it is by the village development council. Chairman, it is issued on 26 February 26, my lord. Your lordship got it, my lord.
So he is working as a chairman of
Chairman of Village Council Development Committee. Village Council Development Committee under Parbatjura BTC, my lord, under BTC, my lord, basically.
আচ্ছা পেজ 34 হলো আমার এফিডেভিট আছে
And your lordship will find page 34 our affidavit. Additional affidavit, my file, page 20. Start from my lord, page 27 onward. Tax payment, my lord, my about this GST. My name is there, Abul Sheikh, my your lordship will find in the page 28. Here also page 27, number 2. Number 1. Then your lordship will find page 30, no?
annual tax statement
Annual tax statement, my lord. Annual tax statement.
page 30
So just I am submitted this thing because just to show that, my lord, I am not that an ordinary person having some sort of, my lord, public and also financial position, my lord.
page 30
It is not that I have taken some money by purchasing or by selling some salt woods, my lord. That is not the case.
page
That is-
34
Then page 34, just have a look to page 34.
what
Page 34, my lord.
we do
A class 1 we contractor, my lord. Yes. 30? Oh. Yes, page tobacco. Yes, page 34, annex F, my lord. Class 1 we contractor also, my lord. So my only question, my lord, since he has already been arrested, my lord, everything is seized, not from his possession. Your lordship admitted, my lord, not from his possession. Only allegation is that they are saying that I am long back, my lord, I am just working this, my lord. My question, my lord, whether further custody interrogation is required or not on the face of this, my lord, without going to other things, my lord. About my ability, financial ability, I have shown your lordship, my lord. Only for the further custody is required or not, my lord. I am for today is my arrested on
29.
29, 12 days, my lord. Last time also, my lord, your lordship, that's why your lordship fixed it today, my lord. I also want pressed by your lordship say that my lord, your lordship is to see the CD, my lord. So my only question, my lord, since it is everything seized, nothing remains to be investigated, my lord. So for the purpose of investigation, my lord, I think his custody is not required. Rest I leave to your lordship.
Well, first of all, I have received the CD. Regarding those, I will later on, my lord, I will hand over the CD to your lordship. But first, I would like to point out, my lord, regarding the observation as pointed out by my learned senior regarding that here, that investigation summary on that, my lord, on the first day of the production, that is on 29/5/2026, accused person was arrested. That is the summary on the first day of the arrest of the accused person, my lord. And thereafter, my lord, on the same day, my lord, trial court has on 29/5/26, trial court has rejected the bail petition of the present petitioner. Your lordship may kindly come to page 22, my lord. It appears that there are sufficient materials against the accused persons under section 3032, 324(5), 3174, 3174, my lord, habitually dealing and, my lord, receiving stolen property of my lord, mandatory period for filing such sheet is, my lord, 90 days. Read with section 24, 25, 40 of Assam Forest Regulation Act 2006. The case is at the initial stage of the investigation, and the offense under section 3174 of the BNS is exclusively triable by the court of session. So, my lord, finding materials against the accused, sufficient materials on the first day itself, my lord, as because, my lord, it would require the initial stage of trial court has rejected. Thereafter, my lord, again the matter was, my lord, listed before this honorable court on 3/6/26 after rejection of the trial by the trial court on 29/5/6/26, my lord. And thereafter, my lord, CD called for, and today I have received the case there. Your lordship may kindly come to page 14, my lord. On that particular day, my lord, the regarding, my lord, seizure, my lord, page 14, that is mentioned in the FIR, seizure list also available in the CD, and photograph of those vehicles, my lord, along with, my lord, SAL logs is also available in the CD, my lord. First of all, one, my lord, Thertheri, my lord, that is, my lord, locally people, my lord, named it as Thertheri, my lord, those vehicles who, my lord, those vehicles were used for carrying all these SAL logs after cutting, my lord. Without number plate, loaded with 35 numbers of suspected to be SAL logs. Again, my lord, one Thertheri without number plate, loaded with 33 numbers of suspected SAL logs without number plate in all these vehicles, my lord. One Thertheri 786 without number plate, loaded with 58 numbers of suspected SAL logs. One white color DI Tata X mobile LGB bearing registration number so and so loaded with 34 numbers of suspected to be SAL logs. Total thereafter again total 27 numbers of extra logs to be SAL tree. One tractor without number plate along with plough machine, white chassis number so and so. So total number of SAL logs, my lord, 187 SAL logs from all these, my lord, vehicles, my lord, police has seized, my lord.
Seized from home.
Seized,
That's
my
your
lord, from abandoned condition. I will come later. I will point out, my lord. And during investigation, my lord, from the statement of witnesses is also available, my lord. How this person, the main kingpin, my lord, mastermind is present accused person. How this accused person is involved in, my lord, in a racket, my lord, in cutting, thereafter, my lord, storing those SAL logs, thereafter transporting to other states, my lord. Regarding those aspects, my lord, photograph and my lord, statements of the witnesses is also there. It is a fact that those, my lord, illegal activities were going on, my lord, for last 10 years. Maybe some other, my lord, might be some, my lord, forest officials may be involved or not, my lord, that will come later on, my lord. But presently from investigation, it reveals that, my lord, he is the main mastermind. Here, my lord, statement of the village headman available, although village headman has not directly implicated the name of the present accused person. Other statement of the witnesses also available that clearly implicate the present accused persons, my lord. That he is the person involved in, my lord, for cutting, my lord, all these, my lord, SAL trees and thereafter, my lord, transporting to other states, my lord. So, my lord, these activities illegal. Not only, my lord, revenue loss is one aspect, my lord. There, my lord, the huge environmental impact, deforestation, my lord. My lord, entire, my lord, that Parbatjura area, my lord, that forest area has totally destroyed because of these illegal activities, my lord. And thereafter, my lord, during investigation, police has seized all these SAL trees. Thereafter, my lord, statement of the witnesses recorded. Clearly, those witnesses implicated that the present accused person is the main person who is running all these business of cutting, thereafter selling and transporting those SAL trees, my lord. And photographs of all those, my lord, vehicle along with those SAL trees is available in the city, my lord. And these are, my lord, serious offense, my lord. And, my lord, investigation as per, my lord, as per the new provision of 187 BNSS, my lord. My lord, as because 90 days offense, my lord, it is not that earlier, my lord, 167 of the, my lord, CRPC that only within first 15 days of the arrest, my lord, accused can be remanded by the police. But here, as per the new provision, my lord, within a period of 60 days, in case of 90, the police can, my lord, at any point of time, my lord, paid for custodial interrogation of the accused person. So, my lord, I will hand over the CD to your lordship. I have trademarked all the vital, my lord, statement of the witnesses, my lord. So my prayer before lordship only 12 days today, my lord, very, my lord, initial stage of the investigation. At this stage, my lord, this is not a fit case for, my lord, granting bail to the accused.
Yes.
And regarding, my lord, that yes, he is a, my lord, that is a additional affidavit annex. He is a class 1 contractor, and those, my lord, that, my lord, he is, my lord, that investigation summary by the IO, that without having any known source, maybe he may be a class 1 contractor, but what type of contract, my lord, he is going on, all those details, my lord, need to be verified, my lord. And by doing this, those are other aspects of the matter, but right now, my lord, for investigation reveals that he is the main cause of the, my lord, these environmental disease, my lord, forest degradation, my lord, these all destruction of forest, my lord, these produce, my lord, he is the main kingpin, my lord, from the my lord, investigation till now, my lord, only 12 days today.
Please, sir.
Yes.
I was listening. My lord. My lord, I am not on my land and friend. Forest, everybody is concerned about the forest, my lord. My question, my lord, so far this case is concerned. Everything is seized from an abandoned place, my lord. Nobody has stated that it was seized from me. Maybe, my lord, it happens. As my learned friend says, with the collision with the forest official, sometimes it do happen, my lord. But so far this case is concerned, my lord, petitioner is concerned, my lord. Nothing recovered from him. So simply by saying that he's very influential and he'll do his mastermind, any substance is there, my lord, your lordship is to see the CD, my lord. Simply they are saying that forests are destroying, everybody is concerned, my lord, about the environment, my lord, nowadays. But whether he is involved, all these things, my lord, have been seized from the abandoned place. Whether anything seized from him or anything is there that how he is involved, my lord. And your lordship, kindly see the page 10, This order is of 10th February 26. 10 February 26, my lord. And FIR is, my lord, page 27, 526. So after scrutiny, also he was appointed as a chairman of the department by BTC authority, my lord. Had there been anything, certainly it could have come, because after police verification, these things, normally the appointment is gone, my lord, after police verification. So suddenly somebody come and say, because they might have demanded money, I have not paid anything, my lord. That may be also reason, my lord. I'm not saying with certain, maybe also, as we have been instructed by my junior, my lord, it is there, but I'm not putting on record, my lord, because it may hamper him also, right? If I make some allegation against the police, my lord. So my question is, so far this case is concerned, my lord. So he is not at all my further custody, is not everything is seized. Everything is seized, and so far my position, I have given all the affairs before worship. And I am not at all involved in destruction of the forest. Because nothing was found on me, and nobody has implicated me about that here. The mayor says I am a mastermind. On what basis? Had it been there, my lord, I could not have been appointed a responsible officer, my lord, chairman of this post after verification, police verification. It is not private organization. BTC appointed him. So I lift your lordship, my lord. I think further custody, everything, whatever is there, they have already collected, my lord. Further custody. I lift your lordship.
Mr. H.I. Chaudhary, then senior counsel, assisted by. You are assisting, or who is assisting? Mr. Board is just.
K.
Keyboard. Also for the petition. Also had Mr. Keyboard put in an additional PP appearing on state respondent. It's an application section so and so. Proceedings. Is submitted by Mr. Chaudhary, the learned senior counsel, that from the FI itself it is seen that all the forest items that is the salon were recovered and seized from an abandoned place. And it is not a case that these articles were seized from the possession of the accused petition. Further, from the investigation summary, it is seen that the IO made a query that without any known source of income, how the petitioner can lead such a life, lavish life. In that context, it is submitted by Mr. Chaudhary that he has been appointed as a chairman of Release Council, a district committee, PTC, and after proper verification of all police record and etc. And he is considered to be one of the respectable person in that locality. That apart, he is a class 1B contractor, and he also submitted some GST registration certificate in his name, and it is further submitted that he is also paying his income tax, and the TDS statement is also annexed along with the petition. Mr. Chaudhary further submitted that the accused petitioner got arrested in connection with this case on 29/5, and since last 12 days, he is in custody. Thus, the IO also got sufficient opportunity to interrogate him, keeping him in custody. Further, he submitted that all the seized articles were seized from an abandoned place wherein which is and the present petitioner is no way connected in the alleged recovery, nor it was recovered from any conscious position of present petitioner. He is a respectable family, a respectable person in that locality, and considering this aspect, he may be released on bail. However, he is ready and willing to extend his cooperation in further investigation of this case if he is granted with the privilege of it. Next back. Mr. Botwood in an additional briefing submitted that the summary of the investigation was prepared on the first day of his arrest. Without further inquiry, in regards to his income. However, on the same date of on the day of arrest, he moved a bail application, which has been rejected, considering sufficient materials against the present petition. He further submitted that from the FIR itself, it is seen that there were seizure of SAL log, which were from 3 numbers of territory without having any number plate. From one number of PI truck without having any number plate, and also some of the SAL logs were recovered from one truck, one tractor without having registration. From the evidence, from the statement made by the witnesses and from the materials available in the case diary, it reveals that the present petitioner is the kingpin of the entire allegation, and since last 10 years, he is doing that business of cutting, selling, and transporting the SAL logs without any permission. Many of the witnesses had implicated the present petitioner, showing his involvement in the alleged offence. More so, the petitioner got arrested only on 29/5/2026, and the case is at the very initial stage of investigation. Hence, further custodial interrogation of the present petitioner may be required to unearth some more facts of the case, and hence he raised serious and raised payment objection in allowing the accused petitioner to go on bail at this stage. Okay, I'll page the record. I have recorded your submission.
Yeah.
I have recorded your submission. Mainly that is an abandoned place, and his source of income we have already explained.
Your lordship will pass order later on. Oh,
Pass the order later on, page the case diary.
oh, my.
of the will. I have recorded your submission, both
My
the
God.
submission.
Order, this will be. Obliged to us.
Oh. Yes, what is the position of it?
May I please your lordship? Lordship, in this case, lordship, case diary was called for. Lordship, the petitioners are on interim.
You have not received the case diary yet?
My lord, case diary not received, my lord.
You are on interim.
Yes.
CD not received. Issue reminder. Yes, what occurred when it can be?
On my lord, interim.
Sir. Let it be after vacation, lordship.
No,
I
my
am on it.
lord, on 25th of June, my lord.
Let it be after vacation.
Oh,
He's on
Let it be
interim.
after vacation. We are on interim.
14th
And
June.
lordship, we are
On
on
the day of
interim
opening
since
case,
last 1
it
year.
can be on 14th only. 14/7.
Ulogans.
From which place?
Lordship, Dhubri.
Golokans to be.
Interim to be continued.
Yes, yes, what occurred when it can.
On 14th.
14/7. Interim be continued till next. Okay, we are
Highly
continuing.
obliged.
19, my lord, also.
This year
So 19 is already 2020.
This year has been received in the matter.
20 we have received.
My lord.
Or it's a scan TCR.
Scan copy. I'm on interim, my lord. Allegation of theft of cattle from dwelling house, my lord. 305 and 331, Red Bit section 13(1) is the allegation, my lord. After interim, I have appeared before the investigating officer. My statement has already been recorded, my lord. So I am the owner of a vehicle. They said this vehicle was used. There is no direct involvement, my lord. So I will appear before the court, my lord. I'll face that file.
My lord, he was granted interim, my lord. They have subsequently submitted, my lord. And cognizance was taken on under section 305, 331, subsection 3, reviewed section 13(1).
305 then
331, subsection 3, reviewed section 13, subsection 1 of cattle preservation. CPA.
cattle preservation.
My lord. And my lord, I have gone to the record, my lord. He is the person, my lord, who used the vehicle, my lord. He is the owner of the vehicle, my lord. With the help of the vehicle group, my lord. There is a group, my lord. All of them, my lord.
The allegation is my
cattle, my lord.
My vehicle was used, my lord.
You also
The driver is someone else, my lord.
No, my lord.
Forwarding report is there in the file, lord.
Lordship, kindly please only his statement, man. How he is involved, man.
And what, my lord, I will face the trial in the matter. I'm already appeared before the investigation. I've cooperated with the investigation, lordship.
But my lord,
Vehicle have already been
here,
recovered. Cause have been
negligent is
recovered, my lord.
section 29(5)(26) for appearance and copy, my lord. Someone was issued, my lord, but till that they have not appeared. Therefore, it's like mark.
So just tell us your interim order, where is it?
16
Interim order?
16/3/2026, lord.
No. Have you annexed the interim order?
No, it is in the orders. This case only I've got the interim, lord. Order it is 16/3/2026. Lordship, kindly put it order is 16/3/26, lord.
It's in which page? In TCR?
No,
No,
not this year, my lord. It's the order of this court, my lord.
Anticipated bail, my lord. At that
Oh,
time,
acha,
he was
which
given
page?
interim order.
20?
16/3/2026.
Acha, 16.3.
2026, lord.
Subsequently, charge sheet submitted.
The allegation, if your lordship sees the FIR, my lord, after 10 days, the FIR was filed, my lord. And lordship, in the file, lordship, I have given one forwarding report. If your lordship sees,
No, I just want to ask you one thing. When 16.3.26, the order of interim was passed,
My lord.
on that day, was the charge sheet played or no? It
No,
was
no,
not.
no, thereafter, subsequent.
Thereafter.
My lord.
Now, my question is it whether his cooperation was there before the IO or no?
Not, my lord.
No.
That is not information, my lord. And
I
No,
appeared, my
information
lord.
get there from here only.
my lord,
What I'm asking, because on 16.3, he was granted with
interim
interim.
protection, my lord.
At that time, it was not charge sheeted.
Not
It
charge
was
sheet.
not charge
CD was called for, my lord.
CD was called for,
My lord.
charge sheet was
My lord.
not there, and subsequently charge sheet was, but in the meantime, he was on interim.
My lord,
I
charge
just
sheet.
want to ask you whether he appeared before the IO during the interim. That's what.
I have
So,
appeared, lord. My instruction is that.
You have appeared.
I appeared.
So that is will be required, because
Minor.
now question is that whether after obtaining the interim he again absconded, that is different.
No.
Or after obtaining the interim, whether he appeared before there. If he already appeared, then further
That is my lord.
custody
That is
may not
their
be
submission.
required.
But my submission is that after my lord, charge sheet, my lord. After charge sheet, my lord.
No, he is before this
my
court,
lord,
so that's why
someone was issued, my lord. Till
yes,
that he has
I
not
can
appeared.
understand. Now my question is that whether he appeared before
My lord, that is not information with us.
No information you get from the CD only.
Oh.
The CD to 9. To CD. It is the order sheets and the last part is CD.
My lord.
So you have to go through. My question is whether there is from his side, whether there was any cooperation.
Right.
If it is there, it's okay. If it is not there, then he acts only, even in spite of having the interim order. That is to be seen. So
After some time, my lord.
okay, after some time then. Yes, Mr. Lal, are you fine? It's
Yes,
okay now?
Yes.
You are okay.
Lord.
When you have arrived? Yesterday?
My brother.
Your brother, na?
Yes, yes. He today, lordship.
Today only.
Today only.
Oh.
I'm okay.
For time being, we have kept it. Just let him go through the case.
Let.
Twenty-one case diary not received, my lord. Petitioner is in interim.
CD not received? No. No one has, none appears on call for the petitioner. Heard Mr. P. Bot food in an additional 50 appearing on behalf of the report. CD not received. Issue reminder. Place the matter accordingly on 15/7/2026. Interim be continued till we're listing it on 15/7.
Yes, 15.
Wait, please, your lordship. Lordship, in both these cases, lordship, this petitioner on interim bail, lordship. In 23, lordship, interim granted on 4/6, 2026, and item number 24, it is on 8/1/26, 8/4/26. Thereafter, on the last day, lordship, there is a instruction from their side, from my learned side, learned friend, lordship. Charge sheet has submitted, lordship. Whether that day court has asked whether the charge sheet is against these two petitioner or not, lordship. That has to be asked.
Again, these two petitions.
And next day is fixed before the CGM on 16/6/2026, lordship. For appearance, lordship.
16-6.
Yes, Lordship.
So as per your report, it is already there.
Again,
I guess.
just look into the charge sheet, Lordship.
Ah.
Their names are there.
Names are there.
Names are there.
So can you also tell us under which section case is charged?
3032.
Theft
3032
case.
Theft,
is
Lordship.
theft.
Theft.
Okay, what is that? Part Mr. P. Chaudhary, Dilanet, and also part Mr. K. K. Das, Dilanet, additional PP, apprehension. It was informed on the last occasion that the case has already been charged, but the only query was that whether the case has already also been charged against this petition. This you have submitted. You have the report. Huh?
No, in the scan copy, Lordship. There is charge sheet is there. I have found their name in the name of the accused person,
You
Lordship.
are submitted it from the scan copy of the VCR. It reveals that these two petitioners are also being charged under section 303 of PNSS, and which is presently pending before which court? CGF.
It's a CGM, Lordship, South Salmara, Lordship.
CGM South Salmara. In view of this, let the interim in view of this, both the petitions may appear before the learned trial court below with an appropriate application for regular bail, which may be considered in accordance. However, till their appearance before the learned trial court below, till their appearance, next is 66.
Section 6, Lordship.
Their appearance before the learned court below on next date of listing, that is on 16/6. The interim granted to the petitioners will be continued, and no corrosive action shall be taken against them till their appearance on 16/6. Okay.
I lay all this, Lordship.
Data disposal. Yes, what is it?
May we listen, Lord?
Yes, we have received here case diary.
Lordship here.
Send back the case diary. Why? For updation or what?
Maybe for updation. Lordship. The IO has prayed for another date, Lordship.
It's a case of under which section?
It is a case of Lordship. NDPS, Lordship.
Pardon? NDPS?
NDPS.
So in NDPS, NDPS, we are seeking pre-arrest bail.
Yes.
In NDPS too, we need the case diary.
Lordship.
So I don't know, it was received, but on the last occasion I have seen here. Oh, you were not represented. Petitioner was not represented. Case diary received, sent back the case diary. So there was no order for retainment. Is case diary still there?
No, Lordship. They have made a prayer for another date, Lordship.
You are Mr.
A. Khalek.
Pardon, Mr. A. Khalek, the learned counsel for the petitioner. Pardon, Mr. K. K. Das, the learned additional.
Section 24, man.
Huh?
24.
Yeah, I can put the 24 group down, 24, age 24, Post CD not received, and it is submitted by Mr. Das that the IO had paid some time for furnishing the update. In view of this, let the matter be listed. He is seeking on 24. Can it be able to?
Lordship from South Salmara, Lordship.
Can be tried.
We will try, Lord.
24. Okay, well, listing it on 20.
May I please your lordship? Lordship, this is second bail application, lordship. Earlier it was rejected on 16/3/2026 by your lordship.
So this time we have received here the case.
Yes, case diary received, madam. Case diary in the report.
Earlier it was rejected on where?
16/3. Earlier rejection order is at page 21.
21.
page 21.
Yes, because it is a subsequent, do you want to submit anything in that?
Subsequent
Is
development is
there
that
any ground for,
the
is there any development?
father of the petitioner is having some medical issues, Lordship. I have
Mother of the petitioner.
father of the petitioner. I have annexed the medical documents at page 24. The father of the petitioner suffered from brain stroke, and he was admitted at Gauhati Medical College Hospital. And one thing, brain stroke. These are his documents, and he was this discharge certificate is at page 27. Just one thing I want to place before your lordship: the FIR was lodged on 17/1, and these medical documents are of the month of December and November. In fact, one thing is that his father needs some more better treatment and some routine checkup. So he's the petitioner is the son, and due to this FIR, he is apprehending his arrest. Therefore, only on the ground of his father's ailment, he may be considered. And another thing is that the FIR also, the lady has alleged that the incident happened in a daylight at 1:45 in a Mochosporkho ceremony in their near the house. And in fact, the allegations which has been made that he has misbehaved with her with some filthy languages and tried to torn her clothes. These are not, I think, true. One thing is that on that day, 16/1, the informant lady met with an accident with the petitioner, and she got some injuries, and they had some earlier disputes also. They are neighbors. The informant and the petitioner are neighbors. They have some earlier dispute also, and out of that gas, the informant has lost the FIR. So my humble submission is that, considering the health of his father, he may be granted interim bail.
Otherwise, my lord, from the earlier rejection order, grievous injury is there. Not only, my lord, again, I would like to remind your lordship regarding the statement of the injured man.
She will definitely support her case.
Regarding medical document of the father, there is up to your lordship. But
He tried to hit her with a car.
yes, well, initially not on the from the initial place of occurrence, one incident happened. Thereafter, again, my lord, he tried to hit with a car, with his car. That is the second incident, immediately after the first occurrence.
This medical report, etc., already there?
Grievous injury report.
Fracture injuries.
Fracture, my lord, your lordship, not there, your lordship. Regarding fracture, I have not regarding grievous injury, my lord, injury on my lord, left arm, thigh, my lord, all this. That injury report I have flag mark. My lord. Regarding fracture, I have not found anything regarding any fracture. That injury is stated to be grievous. My lord. That is the
Fracture was there, ulnar region.
due to the accident, she suffered some injuries. Not because
Accident is,
there was no
as per
motive.
them, it was intentional.
There was
It was
there
not
was
an
no,
accident, but it was intentional, as per them.
yes,
And
but them. But there was no motive for him to try to kill her lordship. The section has been attempt to murder and everything. There was no motive for him to do such things. The lord just lordship may consider the medical ground of his father lordship.
you are the, you are Mr.
D. Chaudhary.
D. Chaudhary.
Yes.
Heard Mr. D. Chaudhary did that. Also heard Mr. P. Bot, an additional PP appearing on behalf of state. It's an application under section city receipt based receipt. Next, submitted by Mr. Chaudhary that it's a subsequent bail application after rejection of the earlier bail application on 16/3/2026 under AP number 259 of 26. He, however, submitted that the FI is not with some false and concocted allegations after on a previous grudge and previous grudge. However, it is the fact that there was a quarrel that took place and no such incident as alleged in the FI. However, she met with an accident, the victim met with an accident, and then only due to the previous grudge, she made the they say she brought some concocted allegations against the present petitioner. He further submitted that the present bail application, present subsequent bail application has been filed only on the ground of the ailments of his father, who had a brain stroke, and thereafter, and at present he needs some better treatment. There is none to look after his father, and he had to take his father for his better treatment outside Assam, and hence he submitted that he may be provided with the protection of anticipatory bail at this anticipatory bail. However, he is ready and willing to extend his cooperation in further investigation of this case if he is granted with the privilege of. Next part, Mr. Waterford, Learned Citizen PP submitted in this regard. There is no such new ground for the subsequent bail application, and the earlier occasion on the perusal of the case record, the petition for his anticipatory bail was rejected. He further submitted that from the statement of the victim, there is sufficient incriminating material against him, and that apart she also sustained previous injury on her person. He further submitted that after the first incident, he again tried to hit her with a car with a intention to kill her, and for that reason only, the victim had to lodge the FIR. Next para, hearing the submission made by learning counsel Coates is seen that except the illness of the father, there is no such new or urgent ground brought in the subsequent bail application. However, from the medical documents which has been annexed along with the petition, seems that the father had a brain stroke. His father had a brain stroke, and thereafter he had to be hospitalized, and maybe may require for further may require for better treatment into that. Only considering this aspect of the case and the case, this court is of opinion that one interim protection may be provided to the present petitioner so that he can appear and can cooperate in the investigation of this case. We'll be under interim protection. We'll see to it. Cooperate with the investigation only on the ground of your father. We have granted you some interest. List the matter accordingly on 16/7.
On 16/7.
16/7.
Nothing.
Is there any counsel for item number 35 and 36? 35 and 36 hearing matters? No, no. I'm not feeling so well because of my leg pain.
Yes, yes.
So I don't want to take the other matters, that is the admission matters and the hearing matters. So if you have anything, just tell us at 2 p.m. There are some bail matters are there and order matters are there. I have taken. We'll
Lordship, may I
Yes.
take a mention? Lordship, in item number 9, the case diary is available. May I pray for a short date, Lordship, with admission matter? Maybe 23 or 24.
Item number 9.
9.
Yeah, yeah. Gimana? Group here, boy. Big boy, group 16. Group here, boy. You are item number 9.
Yes, ma'am.
If we have received.
My lord, CD received, my lord, here, we will have to return back the case diary.
No, he is seeking asking for a short date.
Oh, my lord, then short date is okay, madam.
But short date is difficult for us also now at this stage. It is 24th of this month.
20.
They are going to retain the
We'll
case.
take a chance on 24th, then no, otherwise 24th.
Yes, they are listing it on 20.
Yes, obliged.
CDB written, madam.
Written.
24/6 24. Was there any interim? No sign.
No interim.
4/6 CDB written till next. Okay, well.
Meet with your Lordship.
Yes, I just asked you to see that thing.
My lord,
Yes. Item number 20.
Item number 20, my lord, I have gone through the record, my lord.
Yes.
From the record, it reveals that, my lord, I have found his bail bond, my lord. Bail bond submitted on 25/3/2026, and in the charge sheet also it was mentioned that after getting the interim, he has appeared before the Iowa statement record. That part is there.
That part is there.
In the charge sheet.
Otherwise, any other submission from your side?
My lord. My submission is that, my lord, here only cognizance is taken, my lord.
Pardon?
Cognizance taken on 27/4/2026.
He is not appearing.
My lord. And next date is 29/5/2026 for appearance and copy. It is already over, my lord. But from the record, my lord, after getting the interim, he has not appeared before a court below.
I have not received summons, Lordship.
Someone issued on that day, my lord, 27/4.
Someone already issued.
My lord.
I have not received any summons. Lordship, you protect me with it.
And our charge is not yet framed.
Charge to cannot be written.
Only for copy.
Part Mr. A. They done the council for the petition. So part Mr. P. Sharma did an petition PP appearing on behalf of citizen. It's an application in section so and so.
Otherwise, he is the main person, man.
He is the main person.
Main person, man. His car is used. He has admitted in his statement, my lord, that his car is used and several persons are involved. There is a group of, my lord.
I will face the trial, Lordship, and whatever is there.
Basically cattle theft.
Cattle, my lord.
Cattle.
He has the, my lord, four-wheeler, my lord. And that it was used for that purpose.
Carrying those cattle. So and so like no? So and so scan copy of the teacher along with the case diary is it is submitted by Mr. Lal that after obtaining the order of interim period and the date 16 yes. 16/3/2026. He appeared before the and cooperated in the investigation of this case. The party submitted that case has already been charged sheeted during the pendency of the present bail application and and he is ready and willing to contest the case by appearing before the learned trial court below on each and every day to be declared. However, he submitted that some protection may be given to the present petitioner so that he can appear before the trial court with a regular bail. Next, Mr. Sharma, the learned additional PP, submitted that after filing of the charge sheet, the cognizance has already been taken and summonses were issued to the petitioner, but till yet he has not appeared before the learned trial court. That apart, there are sufficient incriminating materials against the present petitioner, who is the main culprit of this case and whose vehicle was also used for theft and transportation of the cattle. However, he submitted that on basis of his diary, it is seen that the bail order is available in the case record, and there is a note of the IA also in the charge sheet that he appeared and cooperated in the investigation. That's why, considering the entire submission made by the counsel for both sides, and also considering the fact that after obtaining the order of interim arrest, the accused had already appeared and cooperated in the investigation. Considering all these aspects of the case, the order of interim arrest dated 16/3/2026 is thereby made execute with a direction to the present petitioner to appear before the learned trial court below with a regular bail application may be considered in accord. With the above observation, the present stands.
I'm okay.
May it please your lordship. Lordship, this is an anticipated bail application, lordship. In this case, FIR was, lordship, case date was called for, lordship. FIR that is on page 15, specific 3 names are there, lordship. 3 persons were apprehended, lordship. They say during interrogation, they said, lordship, they have cheated 1 person, lordship. Taken 3,50,000 from him, lordship, and after that, lordship, they did not deliver the fake gold. That is the case, lordship, against those persons. Those who were arrested, lordship. Then, lordship, the seizure was made from those persons named in the FIR, lordship. Subsequently, what happened? One of the bail petition was moved on behalf of the accused, lordship. Not this present petitioner. Their lordship, the order, lordship, will find on page 22, lordship. And the certified copy that is on page 26, lordship. And page 27, middle paragraph, lordship. Only in the bail order, this petitioner's name has been uttered by the IO, lordship. Page 27, lordship. That much, lordship. Because, lordship, what happened in lordship, remember this petitioner, lordship, one case, lordship, in civil dress, lordship, the police tried to arrest this person, lordship, he escaped from that, lordship, scuffling. That case, he got the bail, lordship. After that, lordship, since it is scuffling with the police, lordship, anything happens, lordship, this petitioners were searched by the police. He also has been searched by the police, lordship person. This is the case, lordship. Otherwise, his involvement in this case, lordship, probably the case diary will reveal, lordship. So for instruction, lordship, he was not in this case, lordship. There's no way connected with this case.
Yes, Mr.
Sir, case they received, my lord. On that day, my lord, on the basis of specific information, police has seized, my lord, arrested 4 of the accused persons. And from them, my lord, seizure list is available in the CD, my lord. Initially, an cash amount of rupees, my lord, 3,50,000 and other some of the mobile phones of those accused persons were seized by police. And thereafter, during investigation from one of the accused, my lord, one, my lord, golden color metallic piece suspected to be fake gold, weight 603.02 gram, approximately, my lord. That was, my lord, seized from these accused persons, my lord. From all these accused persons, my lord, later on, my lord, during search, my lord. And my lord, regarding the involvement of the present accused person, my lord, Baharul Islam alias Sambani, your lordship probably remembered these accused persons, my lord. Earlier one in, my lord, that bail order is annexed, my lord, in page 30, my lord. In that case, my lord, while police went there to arrest the accused person in respect of Bihpuria PS case number 7925, at that point of time, my lord, he gathered a lot of, my lord, public there. Thereafter, my lord, all those persons, after assaulting police personnel, they would vandalize, my lord, police vehicles, and thereafter he fled away from the place of occurrence. Later on, my lord, he was arrested, my lord, only thereafter in this bail order on the ground of length of detention. And in that case, because there was no such specific allegation at that point of time, he was allowed to go on bail. But in fact, my lord, because of him, my lord, that incident occurred, my lord, on that day. And now in this case, my lord, there are total 4 numbers of cases pending the present against the present accused person. Bihpuria PS case number 393/2016. Bihpuria PS case number 48/2024. Bihpuria PS case 244/25. Dolgaon PS case number 208/24. And my lord, Bihpuria PS 40/24, total 5 cases, my lord. And my lord, from the bail order granting bail to the other accused person, page 27, it reflects that IO of this case has prayed for allowing him to take the arrested accused person, namely Nobi Hussain, in police custody for a period of 2 days on the grounds for thorough interrogation in order to ascertain the nexus and involvement of accused persons with other associates engaged in similar offense of suspected to be fake gold transactions, to trace out co-accused Baharul alias Ambani, he is Baharul Islam, collection of technical evidence such as CDR, mobile data, and modus operandi of the alleged offense. So from the case diary, it reveals that the present petitioner is the person who has supplied that fake gold, and my lord, asked Saddam Hussein, my lord, provided the phone numbers of that victim of who, my lord, who is from Orissa, to contact him and, my lord, hand over this my lord, fake gold. And thereafter, on that particular day, my lord, on being called by the from the case diary, it reflects that after, my lord, when they are probably they collected the amount of money, that is 3,50,000, that was seized by the police, and without handing over the fake gold also, they fled away from the place of occurrence. And regarding that, my lord, investigation is still going on. And my lord, to find out the, my lord, the exact location of the, my lord, victim, my lord, his identity, my lord, and all these documents. And now, my lord, regarding the present accused, my lord, he is a habitual offender, and my lord, earlier also involved. And in this case also, he is the person who has handed over and provided the phone number of the victim who is from Orissa, my lord. Thereafter, Saddam Hussein contacted that.
This statement is made by whom?
Nobi Hussain, my lord. His statement, my lord, I have flag marked, my lord. This is the statement of the Nobi Hussain.
The present case, lordship, 4 persons are named. The recovery was made from this 4 person, lordship. Subsequently, lordship, these are the, lordship, I have already submitted, lordship. After that incident, lordship, one after one case, they are searching and try to implicate this present petitioner, lordship. Anyway, lordship, he is ready to cooperate, lordship. If required, lordship, every alternative, the lordship, on fortnight, lordship, will appear before the police station, lordship, to cooperate with the investigation, lordship.
You are also known as Ambani, na?
Ambani, that is the
No, he is the, my lord, he is involved in many other
They,
cases.
though maximum case he got bail, lordship. Those are lordship under trial, lordship. That will be decided.
And
Till date, he is
and-
not convicted, lordship.
And
Till
after
date, lordship.
obtaining bail, my lord, he is continuously involved in committing the same kind of offences again and again.
Subsequently, what is the case, lordship? After this, lordship, is there any case pending, lordship? And moreover, lordship, in his forwarding report, last forwarding report, lordship, the cases those mentioned in the, by the investigation officer, lordship, that case, lordship, he has got bail, lordship.
My lord, first part of the case diary, my lord, detail about those cases and how he, my lord, the first portion of the city IO has in.
Every case, lordship, has to be dealt separately, lordship. He may not be in lordship involved, lordship, since he is not convicted, lordship. Accusation may be there, lordship.
So immediately after, my lord, obtaining bail, he is again involved in committing this type of offence.
Undertaking, lordship, at best, lordship, undertaking, you can give even undertaking, lordship. And fortnight, lordship, if you appear before the lordship police station, lordship, there is a less possibility to lordship get involved in one such of activities, lordship. If the submission of learned PP is
My lord,
considered as
from the earlier case or in that case, my lord, wherein he already obtained bail, my lord. Although in that case, my lord, there is a gang of persons, my lord, in his favor on that particular day, my lord, in that case, police went there to apprehend the present accused. Then all these peoples gathered while police tried to arrest him. Thereafter, they assaulted those police personnel, those vandalized those, my lord, vehicles. Because at that point of time, the present accused fled away from the spot. Other persons, my lord, assaulted the police person. So that is because of that reason, my lord, he obtained, my lord, bail immediately. Although, my lord, he was arrested after a long, my lord, period, my lord. Police could apprehend him.
that case, lordship, he has not assaulted anyone, lordship. Police has come in a civil dress, lordship. They have not even shown their identity card, lordship. That time, lordship, cricket match was going on, lordship. Probably, lordship, remember all this fact, lordship. Cricket match is going on and he raised even cry, lordship. People come and lordship rescued him, lordship.
So considering the fact that, my lord, he is a habitual offender at this stage, my lord.
If lordship falsely implicated one by one case and showing him as an habitual offender, lordship, what is the position of this case, lordship? In this case, lordship, he was not, nothing was recovered from him, lordship. Only mere statement of the co-accused, lordship.
Police has no.
And it is.
Police has no personal interest to, my lord, vindicate him in, my lord.
Why that's then, lordship? Why
He is
in a
involved-
lordship
he is
civil
involved in
dress he has
committing
police
offences,
has come to arrest this person, lordship? Even they do not show their identity card, lordship. That too, lordship, before the lordship 31st night, lordship. New Year's Eve, lordship.
Each already. And also, Mr. We bought done it recently. On it's an application. It's citizenship. Is submitted by Mr. Chaudhary that the present petition is not and it's not used. And during at the time of institution of the event, 4 persons were named, and those were and they were accordingly apprehended, and the money is also seized from their person, which is amounting to the money amounting to rupees 3,50,000 also seized from their position. Apart from that, the board shipped gold-like gold-like product is also seized from one of the poison of the one of the individuals. the present petitioner is neither an defendant accused nor there is any involvement of the present of the petition in the alleged offense. But earlier one case was lost against him, wherein some police personnel went visited to their village in civil dress to apprehend the accused persons. The present petitioner, when some of the villagers restrained the police personnel from arresting the accused, as they could not recognize the police personnel. They could not recognize the police personnel who came in a civil dress. But after the said incident, he got arrested in the said case, and subsequently also he was elders convicted. But police is searching for the present petitioner, and with that earlier grudge, the case is lodged against him one after another with some false accusation. However, the present petitioner is still ready, willing to extend his cooperation in the investigation of this case if he is granted with the privilege of the arrest rate. Next. Mr. Waterford Ilanit petition raised objection, submitted that from the statement made by the co-accused and during investigation, it has come out that he is the main culprit of this case, who provided the phone numbers and every details of the victim, and also supplied the board secret gold-like product to the co-accused for delivery of the same. Thus, under his instigation and under his leadership, the entire crime was committed, wherein four other accused persons were also killed. Mr. Waterford further submitted that the present accused petitioner has the criminal antecedents, and at present, 5 numbers of cases have been pending against him. That is one Victoria case number 393 of 2016, Victoria based case number 48, Victoria based case number 244 of 2025, and Dolgaon PS case number 208 of 2024. Thus, he is found to be an habitual offender and involved in various trade court transactions or other cases in the entire in Victoria, the area of Victoria. Mr. Waterford particularly submitted that his custodial interrogation will be required, and hence a present petitioner is hence he is not at all attached to grant the privilege of rehearing. Next part, getting the submission made by the counsel for both sides. I have also finished case record and the case diagnosed, where it is seen that on the day of incident, on the day of closing of the FIR, 4 accused persons were named, and they were apprehended, and the one piece of fake gold along with rupees 3,50,000 were also recovered from their possession. But during investigation and during investigation, while recording the statement of the other some of the witnesses, it has come out that the present petitioner is involved in the alleged offense, and rather he is the main culprit of the mastermind of the entire crime, who even provided the details of the phone number of the victim, to whom the other accused person are to contact, were directed to contact, and to obtain the rupees 3,50,000, with showing the delivery of big court. In that report, it is seen that there are many other cases pending against him, and some of the cases are of similar kind of nature. And the entire and the almost all and the most of the cases are found under the jurisdiction of Victoria Police Station under Dr. Police Station. So considering all these aspects of the case and to unearth some more facts of the case and to name the other culprits who may be involved in the entire gang of the and in the gang of the people actually. Some other involvements of the other culprits. It's seen that the custodial interrogation may be required for the purpose of a proper investigation, just and proper investigation. In view of this, the bail petition, anticipated bail prayer for the present petitioner is hereby stands vacant. Your petition stands vacant. Oh, sorry, you stand dismissed.
Lordship, may I pray, Lordship, if Lordship reject it, may I withdraw the case, Lordship, otherwise it will impact the case.
Order pass only.
Sorry, very sorry.
I love, like.
This kind of submission don't make you. Yes, what is 29?
May I please, Lordship? CD was
Just a
called for.
second. CD received here.
My Lord,
Is there
allegation, my Lord, Assam Game and Betting Act, 1970. And so far, my Lord, section 14 is concerned, maximum punishment is 3 years. Now, FIR, my Lord, page 8. Here, my Lord, my name is not properly shown. And here, my Lord, saying Jamo de Raba. Eventually, I am a Jama de Raba, my Lord. And lastly, my name shown, my Lord. Eventually, in the name of Chorak Puja, one, my Lord, dance program was allegedly organized by and managed by Nur Alam, page, my Lord, 8. And Nur Alam already been arrested and he's already in judicial custody. I think, my Lord, in this case, my Lord, nothing recovered and seized from my possession. So, my Lord, custodial interrogation not necessary in this case. And if something recovered and seized from my possession, then I have nothing to say. Otherwise, my Lord, if nothing has been recovered and seized from my possession, and then, my Lord, I am entitled to get this pre-arrest bail, my Lord, benefit of this pre-arrest bail. And I have also narrated under para 6, my Lord. Then I have not invited any and had not accepted beating, and also did not possess any instrument of betting or records of betting in connection of this alleged offense. So, my Lord, lastly, why my name shown in the affair, and it is also wrongly shown, and I have, my Lord, enclosed my page, my Lord, 13, my voter ID card. Here, my name very clearly shown, Jamaday, Jamadai Rabha. And next, my Lord, PAN card also.
Who are you? Jamudai Rabha? Or
I am a Jamadai Rabha, but in the affair, my Lord, other accused name and father's name, address also shown properly, page 8. But so far, my name is shown, Jamude, and on this name.
You are challenging your identity now, or what do you want to challenge?
No, actually, I am not.
You are saying that
I am
your
also
name
not.
is not properly written.
I am not, because so far this name appear, something is found similar. Therefore, I am apprehending to arrest. Otherwise, I am not involved and nothing.
If you're challenging your identity, then it's okay. We will call for the
And
other
nothing ceased from my position.
Now take one plea, whether you are challenging your identity or you are challenging that you are innocent.
My Lord, so far, my Lord, if something ceased from my possession, that is taking into account.
Your Lordship may kindly come.
You are Jamudai Rabha, that is okay.
Yes.
Then why you're
In the
saying
FIR
that your
also,
name is not
Jamudai Rabha
proper,
is-
name is not proper, repeatedly you are saying your name is not proper. I mean, why? What is your name? Your name is Jamudai Rabha only. Some vulgar dances were also organized, nah?
Yes, Lord.
Without any permission from the authority concerned.
FIR reveals there was a dance, my lord.
Hmm.
Program was allegedly organized and managed by Noor Alam, and Noor Alam already been in police custody, judicial custody. He was arrested. I have also narrated in my case, my lord. And another accused, my lord, Noor Islam, Saibari Muslim Para, his address also shown. And another, my lord, Ali of Saukadala, address also shown. Moinul Haq of Saibari Muslim Para, address also shown. And lastly, my lord, here, Jamode Raba also shown. Now, my lord, humble submission, if something ceased from my possession, whether something ceased, otherwise I am not involved in this case.
The question of seizure will not arise because, my lord, they are involved in, my lord, organizing that obscene, my lord, the dance program, and, my lord, organizing illegal, my lord, gambling activities. And regarding that aspect, my lord, there are many witnesses, my lord, here. All these witnesses stated that, my lord, Noor Alam, Noor Islam, Elias Lengra, Moinul Haq, and Jomudoy Rabha, the present petitioner, all named that all these accused persons are involved in organizing these, my lord, activities. There are many witnesses, my lord. 1, 2, 3, 4, 6 witnesses, my lord, named the present accused persons. He, along with other, my lord, Noor Islam, Noor Alam, one Ali Hussain, Moinul Haq, are involved in organizing these programs.
But the question is that there are only two main allegations that they have organized the illegal betting or the illegal gambling.
Yes.
And that apart, some vulgar dance was also organized in the said Mela.
Yes.
But during the operation or at the time of when the information was received, the operation, when there was an investigation or whatever is conducted. During that period, whether from any other person, any gambling items like the records
No,
or
no,
any
regarding seizure, my lord, I have not found.
Such kind of seizure is not there. But basically, it is the allegation that he is also one of the organizer.
Yes. Seizure list is not there.
Pardon?
One organizing committee's, my lord, statement, president and secretaries, my lord, one statement is available there in the CD, my lord.
There is the president secretary means who are they? Who are they? They are the organizer or
They are the, my lord, president secretary of that, my lord, Soibari, Sorab Puja and Mela Committee. My lord.
Lordship, I would like to one decision, my lord. If nothing has recovered and ceased, my lord, then I am entitled to get.
Every case recovery is to be there. It's not binding rule, na?
Yes.
Lordship, this is my
Is
lord.
there are many cases. There are many maybe different aspects. There are many.
This is my lord.
May be different.
Honorable.
Invariably, every
Honor-
case there has to be. Is there any rule?
Honorable High Court, my lord, pass this order, my lord. I relied upon paragraph 8, my lord.
Why rely?
It is also 11, my lord. It is also Andhra Pradesh Gaming Act 1974.
This order was passed by which court?
Honorable High Court, my lord. And here also regarding allegation of Andhra Pradesh Gaming Act, and paragraph 8 also perused on Supreme Court judgment in Bulu Das versus State of Bihar, citation 1998, 8 SCC 130. Paragraph lordship 7 and 8. 8 is very
This
necessary.
was the
Perusal of
secretary
record.
had informed.
Informed. And regarding last,
that no such kind of thing. Would
yes,
be,
the last portion of the CD
but
statement.
they are not the accused, na?
They are not the accused. Last portion of the CD, my lord, the statement of the witnesses, my lord, named as Damodar Raghavan. Maybe some organizers also, my lord, may be involved. Otherwise, my lord, how they can organize such a mela in that. But regarding those vulgar dance program, my lord, that
While police was there, they could have at least tried to
Yes.
get some
Only because after media publicity, my lord, probably, my lord, some action taken, my lord, that kind of situation. Because that was published, my lord, in various news items. So,
okay, Mr. Give me an internet counsel for the petition. Also, Mr. Report of Good Internet Edition PP appearing on Sector 1. An application, section Swenson, connection Swenson. Submitted by Mr. Clear the present accused petitioner is to be considered in the LSF. Nothing has been seized from his position. And he is also not involved in organizing any illegal activities of gambling or vulgar dances, as alleged in the act. He further submitted that his name is also not properly mentioned in the FIR, though it fact that he is one Jamudai Raba. Jamudai Raba. Mr. Huya further submitted that the present petitioner is no way involved in the LS office, and nor he was an organizer of the state. However, he is ready and willing to extend his cooperation in the further investigation of the case if he is granted with the privilege of rearrest. Next one, Mr. Waterford, Learned Edition PP submitted in this regard that there are sufficient documentary materials against the present petitioner also, who was stated to be one of the organizer of this illegal gambling activities as well as some vulgar dances in the said Mela, which was Mela. Further, he submitted that the president secretary of the Mela also assured initially that no such kind of illegal activities like gambling or vulgar dances, etc., will be organized, will be permitted in the said Mela. Apart from, but instead of that, in spite of that, the such illegal activities were being organized in presence of the present petitioner along with the other. The party submitted that some of the witnesses have also uttered the name of the present petitioner. However, till date there is no recovery of any recovery made by the police during investigation. Next, considering the submission made by Learned Counsel proposed as materials in the case diary. Other aspects of the case, this court is our opinion that an opportunity can be given to the present petitioner to cooperate with the investigation of this case. And in view of this, I find it case to extend the privilege of free respect to the present with petitioner with strict compliance with the liquidity process. Okay, we're done.
Hello, best. I will cooperate. Obliged, Lordship.
Non-appearance for the petitioner as well as respondent. Please see matter accordingly after vacation as on the date to speak. Hey. Yes. Good.
And other councils of admission matters, probably they are under the impression that admission matters will not be.
I asked, that's why at that period of time that if you want
Yes,
any
yes.
date, we accommodate.
Yes.
But they did not say anything, the council, on the
Yes.
council side. So now we are calling for the case record, cases. MSD goes, I have seen her in the morning she was
Yes,
there
and-
as an amicus, most probably she was an amicus. Based on data market to find and appears for the petition as well as interim के बाद से was unable. Create. Itu gimana customer? Customer aku naik interim, which Shamil customer interim naik. Naik as usual after vacation as an deputy at least. Aru 7 to just check for it. Interim scan for the answer and an application call for a petitioner as well as respondent, item number 70. Further, the scanned copy of the TCI is also not been received by the concerned section. Issue reminder, call for the scanned copy of the TCI and TCR along with the case type. It would non-application for a resident hard P portfolio. Here is a interim question of interim is not here, so we're listing after vacation.
Yes.
It will be according to listed after vacation is on a date. Yes, so why it is in order call?
My lord, actually, we have taken steps upon respondent number 2 and 3. And thereafter, through the concerned PP, my lord, and PP office, through the police, Dispur police, OC Dispur, yes. So, my lord, as because these persons were not.
But your office has received the notice. I think.
Yes, received on last occasion. It received, my lord,
The
because.
public, no. Office of the PP received the notice.
No, but already they collect the report. These persons are not available, my lord.
No,
I think
report is already there.
Report is with.
Yes, good one.
Yeah.
That report, my lord, says, sir, with due respect, I have the honor to report you that your honorable court directed me to serve this notice to Vivek Pukon, resident of Syndicate Orchid Apartment, Hengrabari, PS Dispur, District Kamrup Metro, Assam. However, I have made several attempts to serve this notice to the said person, but fail in each time as the person left this apartment 3 years ago. I have taken the signature of the caretaker of Syndicate Orchid of other block. Therefore, I hereby return this notice back to your honorable court and a prayer to fix another date for the same. So, my lord,
So basically, this is a petition for quashing if an order dated 7/8, whereby the cognizance was taken on the other order.
My lord, before that, one more thing is that this Vivek Pukon, he himself lost the FIR on 18/6/2024. But the report showing that he was not available in that particular address for about 3 years, my lord. This, I don't know what is going on behind this, because kindly see the FIR.
my lord, there are two respondents, one another, my lord.
Rohit Burman.
Rohit Burma is also there. Regarding that, Rohit Burma also, my lord, I have received one report. Assam is not found at that area. Hence, I hereby returning this notice book to your honorable court.
Well, what he will do, my lord? This
But your address is proper.
Yes, my lord. Because it is reflected in the FIR, and they took Jimma on the basis of that FIR, my lord. The Jimma order is also there, lordship.
Jimma of what? The vehicle?
Jimma of the vehicle. I purchased the vehicle from this Luhit Brahma, who was the owner of the vehicle was Vivek Phukon. Vivek Phukon
So
handed
at present, the Jimma is with Vivek Phukon.
Vivek Phukon.
Then he is the necessary party, na?
But please, lordship, see the conduct. See
No, I'm not on that.
My
Suppose
lord.
order is also passed. In that case, also he will be a necessary party. That's what I'm saying.
My lord.
Suppose if order goes in your favor also.
But
That case will
orders showing that he was not available. Police who handed over the vehicle to that person on Zimma. That person, he has stated in his report, this person is not available since 3 years back. But the address is there.
No, I'm not on that. Yes, you're rightly submitted.
My
If
lord.
it's not there, though
My lord.
FI is seems to be instituted on 2024. Yes,
My lord.
that can be understood. I am not on that. I'm just asking. Suppose that order is set aside or quashed, or maybe Jimma is given in your favor. Say suppose. In that case, also, if the person cannot be, I mean, traced out, so again we'll feel difficulty. Otherwise, we can say that it is not there, and okay, we'll deem to be
served.
Not exactly deemed to be served. It is not there. Or what?
My lord.
Yes, is there any procedure?
Otherwise, one other aspect is also there. Yes, he has filed this criminal petition against the order of the learned trial court. But one other, because in that case, my lord, on the basis of the report of the IO at page 36, the vehicle is in the, my lord, registration is in the name of Vivek Pukon. So on that basis, trial court has, my lord, granted Jimma. So Vivek, suppose, my lord, those are question of fact, my lord. Now, because already interim Jimma granted to one Vivek Pukon, whether those questions, my lord, that he is not the rightful owner, the present petitioner is the rightful owner by way of this criminal.
We'll hear to that. We'll hear to the matter. Now it is in order come, so we pass the order that next day.
Yes,
it will be listed in the
And
addition.
I am not the what my learned friend has suggested this
my lord,
regarding this order.
She needs to paper publication, my lord. Otherwise,
No, my lord, the thing is that if the person took the Jimma showing this ownership, lordship, so court on the faith that this trial is going on, so vehicle has been given Jimma to the person. So how can this person is not available in that address? First thing, and then he, as per his affair, he has stated that I sold the vehicle to person. He received the money. So after that, he after the lordship agreement between the both the parties. After that, now he took back the vehicle, showing this reasons, lordship, and I am suffering. My pecuniary loss is involved in this case, lordship.
otherwise, my lord, his interest will be affected, my lord. Anyhow, his presence, my lord, is necessary.
That's what I'm saying. His presence is required.
Yes.
This way or
Even
that
I
way also. his
even
presence is
even I
required.
give the paper publication also, lordship. In that case also he will not appear. In that case,
Suppose paper publication also, then also he has not, my lord, suppose my lord have not gone through that particular, not for many reasons, my lord, he has not gone through that. In that case also, my lord, because this is not case like me in a civil case that paper publication published and thereafter, my lord, accordingly in order passed in the civil. But here his interest, he has filed Jimma application before the trial court. Order passed in his paper on the basis of the report of the IO that he is the registered owner of the vehicle, my lord. And thereafter, my lord, without
phone number is there, my lord.
now
Particular phone number is there. IO is the responsible person here, my lord. It is his duty to find out the person.
He, as per his report, he tried on many occasions, and last time I have come to know that the person is not available for 3 years in that apartment. One affidavit is, I mean, one thing is also there. So now,
What I will
say
do, my
that
lord,
he is not trying. He tried his best to serve the notice, but he is not. The person is not available. So that is the reason.
my lord, if suppose the vehicle is required in the case, then how he will find out
That's
the,
what I'm saying, that his presence is necessary.
my lord, this is the
Just what I'm
problem.
saying, because even if your order is
It's a,
passed
it's
in
a,
your favor,
it's an interim order, my lord. Jimba is an interim order.
no, obviously,
lord.
suppose the interim order is that is set aside or cost whatever, but where the vehicle now? The vehicle is in possession or jima of that particular person.
Yes.
So now, if he is not there, so in that case, even if order is in your favor, goes in your favor, suppose, in that case also it is necessary, his presence will be necessary.
How, lordship, how they will find,
Last try you make it, what to do?
in
Last
what
try
way,
is
my
of
lord?
through paper publication only. Yes, that in many cases it does not serve the purpose. I can understand paper publication also. So
My lord,
he is basically resident
my
of
lord,
which
we
place?
can do one thing more, my lord. Like, this is a registered vehicle. It is still running, my lord, in running condition. If they find out the vehicle, then this person will come out.
My lord, one question, how, my lord, the
How can
petitioner,
you direct to find out the vehicle?
তুমি petitioner টো কেনেকে গম পাইছা? চিনি পাইছিলা?
এইটো এফআইআৰ দিছে ন চব কি কৈছে এফআইআৰখন আছে ন মই কমপ্লেইন ফাইল দিছো অ বিবেক ফুকন
If he purchased from Vivek Pukon, my lord, the vehicle, then he can also find out, she can
how
also
is it
find out.
possible, my lord, if IO is not finding out the person, is it
His
possible on my
presence will
part,
be
my lord?
required, either this way, that way, whatever, but his presence will be required.
But my lord, see the condition. If IO is not finding out the person, is it possible on my part, my lord, to find out this person? They are here, but
No,
I don't know.
At best you can try to locate his present address, because he is not available in that.
Well, he is
apartment.
available, my lord. I don't know
Because
why the IO
the
is
present
that
case is,
apartment.
yes, he is
well,
available.
because
my
the
lord.
present case is pending before the trial court, my lord. And trial court, all my lord records regarding his address, everything is there, my lord. Let my lord, as because his presence is required, my lord, to participate in the present, my lord, criminal petition. Let him, let her file by stating all these facts, report that, my lord, from the trial court.
My lord, if High Court
No, he is
direction
saying
is
that
not following,
the person is still in the available in the apartment.
Let him first, my lord.
Caretaker's thing, one certificate is also there. But Miss Nagis is saying that he is still there in that apartment.
no, গন্ডগোল যেতিয়া লাগে তেতিয়া মনে থাকে we have filed also CR case also against him, my lord, stating all these things. But thing is that what my concerns go here, my lord, if a person took the Jimma, my lord, how he evade all these things, my lord?
That is known to him only. How can we say? That's what I'm saying. Even if order goes in your supposed favor, but
Yes.
in that case also his presence will be required. Otherwise, how can say order of
My lord,
Jima
I
may be
think
in your favor?
IO is the responsible person
my lord,
because
first of
he
all,
filed a
vital evidence
report.
is that, my
He
lord,
submitted report before the magistrate, my lord. He is the original owner, he has stated. So it is the responsibility of IO. If IO will take the responsibility, then it will be better for us, my lord.
I already took the responsibility. That's why he submitted the report even with a certificate or the note of that caretaker also. That person is not available in the apartment for last 3 years.
Then, my lord,
Whether he sold that apartment, that is not known.
And my lord, I do not, but otherwise, from the report reflected, actually, my lord, registered owner is Vivek Pukon.
Yes.
Otherwise, my lord, he is not.
Vivek
registered.
Vivek Pukon has stated in his FIR that I sold the vehicle to respondent number 2. Respondent number 2
Okay, then
sold.
if you think so, Mr. Then we'll hear, you can hear the matter and
Yes.
let it be on hearing.
Yes. Yes.
Hard MS SKNR still on a council for the petition. So hard Mr. P. Bonda court still on it additional PP every office note. It is said that the services still awaited for the respondent number 2 and 3. 2 and 3. However, it is submitted by Mr. Bortapu that the report is received from the concerned police station, wherein it is reported that the respondent number 2, is not available in this apartment since last 3 years, and hence in spite of his best effort, he could not serve the notice to the respondent number. And in no other, he also took a certificate from the caretaker of that apartment, where from also it is seen that the respondent number 2 is not available in the said apartment since last 3 years. Coming to the notice issued on the respondent number 3 also is reported by the IO that the respondent number 2 is also not available in his address locality, and hence for which the service they could not the notice could not be served to the respondent number.
If he wants to publish in paper, my lord, that direction may also, one direction may can also be.
Can be. In view of this, finding no other alternative, and also considering the fact that the presence of PW respondent number 2 and 3 is very much necessary, this court is opinion that that the notice may be published through the notice may be issued through paper publication. You can spend how money for 2 papers or 1 paper. Otherwise, one is English daily and one is SMS daily.
Only one Assamese daily.
SMS daily will sufficient. Notice here is SMS daily. Proceeding will be too.
Yes.
Proceeding will daily widely circulated SMS newspaper, either through Proceeding or one more any other paper or
any
public. I'll give the stock market.
Proceeding or Neomia Bhattam.
Neomia Bhattam. Proceeding oblique Neomia. তার affidavit এখন দিব লাগে না? Just try it once. Let us see.
My lord, in the meantime, a direction should go to the investigating officer, who is the responsible person here, my lord. Because he has submitted
What
the
kind of
report.
direction down you need?
My lord,
He has done his.
I am also
Done his
confused
case
in
and
this case.
that apart, he has also submitted one item may be
My lord,
certificate on.
phone number is there, my lord. His phone number is there in the FIR, my lord.
No, we are entrusting his duty only to serve the notice.
Yes.
That apart, he is not taking any investigation at present time. So that petitions cannot be given. Rather, you can try. You
Because
can go to your this DTO office and all, and if any other address is there, or suppose this may be a temporary address also in either village or any district or any other district. If it is there, suppose permanent address in a form of permanent address, that can be collected also. Or then we
Should
can
I
make
go
a
for
direction
the
to you
dusty
also.
service, my lord?
Dusty will not be there. We can make a direction to you, oblique. In the meantime, the petitioner will
No,
also
I
try
have
to
sound try for reply.
get a permanent oblique present address of the petitioner, of the respondent number 2. You try just once to get a proper address from the office of the DTO also, if there is any permanent address, other permanent address. We don't know. Just I'm saying. So one option is that paper publication. Second option is also there. I have given you in the meantime.
As my lord, I also seeking time as per regarding Vivek Pukon, my lord. One more na tada notice kon likha ase na. Through the IO also, my lord. Once, yes.
Doctor, therefore, I hereby return this office back to your honorable court and a prayer to fix another date.
That is
Already he has submitted this report.
Return
another date.
How can
That
another?
is, my lord, his writing
It
language.
is not his case to fix another date. He is writing.
If my lord, again once more through the IO.
Now, my lord, she has
Serve your
submitted,
purpose. It
now,
will
my
rather
lord, she has
delay.
submitted this, she wants to dusty service. So if dusty service she wants, how he can find out Vivek?
No, if
she can find out.
I'll get, my lord.
If you
I'll
have any
get,
source, just let us know. The court will help you. That's why I'm saying that you can approach the office of the DTO so that it can be sorted out if any permanent address is there. List accordingly after vacation as an date.
fix a date, my lord.
You want any fixed date?
Yes. Any date, just after reopening.
20 after vacation.
20. I'm also confused in this case what to do, my lord.
Your money gone already.
Money gone. Because of want of, he wanted to ride in Polestar vehicle. Or that is why he is
Oh, it was a Fortuner?
Yes, ma'am.
Oh, very nice. That's fine.
Obliged.
Mr. Chaudhary, it is in white, is in order column.
Lordship, on the last occasion, my lord, there is a office note. Lordship kindly see
Please note.
on 5/6.
Okay, okay.
Lordship is not well, so I am not entering into the file. On 5/6, my lord,
Item is delivered.
yes, delivered. And the last order is also there to that effect. So delivery is there.
Respondent also appeared.
My lord, only thing I
Respondent
prefer.
appeared.
Appeared, my lord, name shown, my lord.
Oh, no.
Oh, no, sorry, my lord.
No,
This
it
is
is not.
additional.
Only my limited prayer is there, my lord. Since her Arunodoy benefits are deposited in the said account, she's poor lady, my lord. She's not in a position. She's not charge sheeted. Her name was not there. No way she involved. Only allegation is that some money were deposited in her account. That allegation is there. So I pray for a
Why
short date.
this here these two respondents.
Yes.
One is branch manager.
Branch manager.
And other one is officer in charge. So you are representing him.
Yes.
For one, I think.
One name of additional PP is there that we can, I can represent.
No, not for one, not for two only.
Two only.
But one is the branch manager. Why it is not served?
My lord, this is served
It
from
is
police
served.
station.
It is
Served
served.
from police station. That is 5/6, my lord, ordered kindly see. That is served. And report flag XY, my lord.
It's good idea.
That
But
is
causally it is wrongly shown as respondent number 1.
Pardon?
Additional PP for respondent
Yes, yes.
wrongly.
For respondent number?
2. It should be 2.
Two. It should be
yes.
two, in
It
fact.
should
It
be
should be 2. I pray for, my lord, a short date, my lord.
But Mr. JMH Chaudhary, short date we don't have as such. But Mr. JMH Chaudhary,
My lord, during service of
also part
notice, my lord, much time has
done
gone.
petition PP appearing on this number. In person to order the date 1/6/2026. The one office note has been made on 1/5/2026, wherefrom it is seen that the track consignment report has already been traced, and as per the report, the item is delivered to the addressee, that is the respondent number 1 on 13/4/2026. The reports of the track consignment reports are also been flagged in view of this, but today also there is no representation on behalf of the respondent 1. In view of this, it is deemed that the service is already completed on both respondent number 1. Let the matter be accordingly listed in the admission. We don't have short date. Immediately on vacation, 14th of July. That apart we don't have.
Before vacation, my lord.
Before vacation. There are some other matters.
My lord,
14th of July.
my lord, only will take 5 minutes. But what happened? Only her account is not operating.
Okay, 14th of July, we'll see. 14th. Immediately only vacation. In admission column, we are listed. Getting my
Wait, please, my lord. So the scan copy of the TCR was called for, my lord, which has not been received. But if I may take my lord to the last order of my lords, 14/5/2026, my lord. Yeah, there was a confusion, my lord, that the order reads as, my lord, that however, it is submitted by Mr. Bothakur Learned, senior counsel for the petitioner, that as per the information received from the additional public prosecutor Assam, the matter was inquired with regard to filing of charge sheet being charge sheet number so and so, dated so and so, but the same was not found in the concerned record. So, my lord, the number which has been provided that, my lord, we have inquired for the, my lord, trial court for the CJ, my lord, but that we could not find any charge sheet in this particular number, my lord. So a direction was issued to the, my lord, learned PP, my lord, so that to inquire into the matter.
Yes, ma'am, I will get the instruction.
The can is also awaited, I think.
In my file, my lord, actually one sheet number also, my lord, there. But whether now
209.
submission is that, my lord, that is not the there is no such record in the trial court regarding filing of such sheet, then I will have to again, my lord, verify. Ma'am.
Because TCR will be there only when the charge sheet is there, or we can call for.
Yes, yes.
But it is now confusion whether this charge sheet number was there or not. I
But in my file, that is CS number 209/23 dated 30/11/22.
This is the charge sheet number.
Search sheet number. No. But my lord, then while my learned senior submits that that is not the, my lord, there is no such record regarding that search sheet, I will have to verify.
Otherwise,
You're saying after verification.
after verification, as per instruction. Otherwise, your lordship may kindly see the FIR, your lordship, the ingredients under ST Act, your lordship, that will not be affected, your lordship.
Yeah, today I'm not going to
Lords,
hear the matter.
lords.
Some problem is there. So what to do, Mr.
Well, lordship may fix
Suppose if the charge sheet number is not the
yes,
number,
Telling.
then obviously, then you call for the case. Yes, earlier occasion case diary.
Case diary was called for, and that when they submitted that,
available in my lord, e-court service also, my lord, e-court service is
একদম অফিসত গৈ চাই
official, then I will have to verify.
One more order ST to requisition of PCR.
our difficulty is this, your lordship. Because of pendency of the case, your lordship, is in some employment, your lordship, opportunities, your lordship, these are considered, I have to reveal, and when case is pending, they automatically reject
yes,
me, your lordship.
Obvious.
And the person who has lost the affair, he has also lost interest in it. In spite of services notice, he has not come, your lord.
Yes, Mr. Potakur, what to do? Otherwise, you just try to make it, because what Mr. Potakur is submitting that 209 is not their CS number.
That is the CS number that is in my file. Record in my,
No, he can take press instruction from the concerned police station, your lord.
PS number.
Yes, I will get.
So you do one thing, say the particular PS number on the basis of which you just make an inquiry whether any CS is submitted, that much.
Yes, yes.
In that case, we will come to know that whether CS is there or CS is not there.
Yes.
Right. Because cases of 2022.
Lord.
Yes.
Mr. S. Potakur, DPR 35. S. Potakur, Ilanet, senior advocate, assisted by Mr. R. Sensu, Ilanet, counsel for the petitioner, Mr. B. Potakur, Ilanet. In the order date 14/5/2026, this court asked the additional PP to make an inquiry as to whether the charge sheet has already been filed in connection with the present case, and the TCR was also. For Mr. Potakur, an additional PP submitted that as per his record, the charge sheet number is 209/3. In that view, the additional PP is hereby asked to take instructions as to whether what is the PS number? Gitanagar?
Gitanagar 137/20 2017.
As to whether any charge sheet has been filed in connection with Gitanagar PS case number 137/2017, registered under section 294/507 IPC, read with section 67 of the IT Act and section 3(1) and clause 10 of the Scheduled Caste and Scheduled Tribes bracket of prevention of atrocities, bracket close act of 1989. However, it is further submitted by Mr. Waterford, the counsel for the senior counsel for the petitioner, that on his verification, it is found that there is no charge sheet number 209 of 2023 dated 30/11/2023 in connection with this. Further, the registry is also hereby directed to call for the DCR if it finds that the case has already been charged. Or no, if charge sheet is not there, we have to call for the case diary.
Yes, yes.
Also, the planet PP may also call for the case diary in the event that if the case is not yet charged. Just inform, inquire if the charge sheet is
Yes.
not there, we call for
Yes.
the case diary.
Yes.
Otherwise, registry will do the needful to
Yes.
call for the case.
Lordship may fix it on 21st of July, or Lordship.
21st of July.
Lord.
We were fixing it 21st.
Diploma.
Yeah, please, Your Lordship. Lordship, I beg to, it is on behalf of Mr. E. Ganguly, Lordship.
Yes.
He's currently suffering from severe backache. He didn't appear
Not for
before.
the other
Lordship.
side.
Lordship, except one or two occasions from my side, Your Lordship, it has been going on for a long time. If Your Lordship may peruse the order, they take one adjournment after another, Your Lordship. Last time I had difficulty. Actually, someone else, I missed out the cause list somehow. But if Your Lordship, there are several such adjournment seeking prayers, several, not one.
If that is that matter, Your Lordship, last date, we actually called them up. The matter came into being. We called them up. It was again relisted, Your Lordship.
Yes.
And however, there must be some problem. He
It was
couldn't
real.
appear.
I'm not speaking about today, Your Lordship. There are several orders, Your Lordship.
A short date may be fixed, no problem with that.
Without, by taking a stay, Your Lordship, this has been going on for a long time. Yeah, last time they called, I missed that somehow. Someone stood on my behalf. On his consent, Your Lordship, this date was fixed. And again, they
Yes.
have come up with this prayer, Your Lordship.
I get that, Your Lordship, but any date, short date may be fixed. No problem with
Next
that.
week, Your Lordship.
Yes, next week,
Next
Your Lordship. No problem. Tuesday next week.
Tuesday. Or the Thursday. Wednesday.
Yeah.
It will be.
23rd or 2nd.
It is not on the next week. That it will be the week after the next week.
Next week, so we don't have any. Sorry, next week. At this, he is saying that 2030, so many matters are there because it is hearing day. And at best, we can list out on 24th.
Gotcha.
We don't have any other. For Goiribo, but you are Mr.
T. Chetri.
P. Chetri, appearing on behalf of
A.
A.
Ganguly.
Ganguly. Appearing on behalf of Mr. A. Ganguly. And also had Mr. I have sent it on here, phone number 1. Is submitted by Mr. Chetri that due to severe backache of the and his concern, Mr. Ganguly is not in a position to argue. Mr. Hussain raised objection and submitted raised objection submitted that in many occasions the petitioner side has prayed for an adjournment and the matter is pending since 2020. Considering this submission made by learning council, the parties are hereby directed to complete the detail of the negative listing that is on 24. 6. Try to hear.
Your Lordship, an attempt may be made to dispose of the petition on the.
Sure, Lord.